Hey, welcome everyone. I think we're going to go ahead and get started. It's a couple minutes after 9. We've given everybody a chance to grab a cup of coffee and get settled. Thank you to everyone who is joining us this morning. We're really happy to have you. Our CLE today is going to be covering information about the financial health of LGBTQ plus communities and how COVID-19 has impacted our legal needs. And we're also going to be offering an overview of some of the really common financial legal issues facing LGBTQ plus communities, particularly trans folks, that include things like bankruptcy, some common consumer protection needs, debt management and collections, and also navigating inconsistencies between identity documents and financial records. And we have four really amazing and skilled presenters today. My name is Denise Diskin. I'm the Executive Director of Q Law Foundation of Washington, which is the host of the CLE. I'm going to be here in the background today, helping monitor the chat for questions and also helping us keep on time. But otherwise, I will not be delivering information. Our speakers today are Alphonse Littlejohn, uses they and he pronouns. Al joined Q Law Foundation in January of 2021 as our first community legal resources manager, which we are really excited about and really lucky to have Al. Al has a lifetime of QT BIPOC experience. QT BIPOC is a term you might hear a lot today. It stands for queer, trans, Black, Indigenous people of color. And Al has been organizing and building queer and trans community in Washington and the Midwest for over 8 years. They are a Midwesterner by heart, a Capricorn by nature, and Al is a Kiki ballroom kid, resource finder, community connector, drag performer, professional napper, people lover, and systems challenger. And when they are not working on dismantling systems of oppression, they like to travel to meet Black trans family across the country, playing Sudoku and laughing at memes on the internet, which I think is a hobby we can all relate to. We also have Jefferson Coulter with us today. Jefferson uses he, him pronouns and is an attorney with Northwest Justice Project. He is the statewide advocacy counsel at Northwest Justice Project and oversees the consumer, employment, and reentry advocacy work. He served previously as the managing attorney for NJP's Spokane and Tri-Cities offices and also as a staff attorney with the Spokane office. And has extensive affirmative litigation experience in federal and superior courts and co-counsels on systemic affirmative cases, and is an alum of Gonzaga University, Eastern Washington University, and West Virginia University. Kim Gunning, it uses she, her pronouns, and Kim is an experienced and creative litigator. And as somebody who has been a colleague of Kim's since the very beginning of my legal career, I can certainly attest to that. Her practice focuses on commercial and complex litigation in trial and appellate courts. And she also counsels clients on compliance with state and federal consumer protection and advertising laws. Prior to her current work at Focal Law PLLC, she has handled a wide range of litigation matters, including many cases of first impression. She was a former Assistant Attorney General in the Consumer Protection Division at the Washington State Attorney General's Office and was also appellate advisor for that division. Some highlights of her work from that consumer protection work were acting as lead trial counsel in a 3-week bench trial challenging a leading energy shop manufacturer's deceptive and unsubstantiated advertising that resulted in nearly $4.3 million judgment in penalties, attorney's fees, and costs. And that at that time, it was the largest Consumer Protection Act award to the state as the result of a trial. She also has been a leading litigator on some other important civil rights cases with the Attorney General's office, including the Arlene's Flowers case, which is a really amazing case related to LGBTQ civil rights. And then our last speaker today is Danon Penta. Danon uses he, him pronouns, and he's a staff attorney with the Yakima office of Northwest Justice Project handling housing and consumer cases for low-income clients. He's a member of NJP's statewide bankruptcy team and handles court debt and legal financial obligations, criminal expungement, and driver's relicensing matters. And previously served as the executive director of Spokane's Center for Justice. And prior to that was in private practice in Seattle for 15 years, focusing on bankruptcy collections, community associations, foreclosure, and real estate matters. He was also the third president of our sister organization, the Q Law Association, and has also been president of the Asian Bar Association of Washington and the WSBA Young Lawyers Division. And when he retires, Danon hopes to move into a tiny house and play a lawyer on TV or in the movies. I love that. So we are just really, really thrilled to have this team of folks. We have some really deep expertise with us today, and I'm just really excited about our agenda today. Al, can you bump our slide forward to the agenda, please? Thank you. So what we're going to do today is we've finished the introductions, check and check. And Al is going to start us off with an overview of the financial health of LGBTQ plus communities. And then Kim is going to talk to us about mortgage and credit discrimination and some of the reporting and remedies available for that. And then she's also going to talk to us about the impacts of gender transition on things like creditor notification, the Fair Credit Reporting Act rights and credit reports. Then Jefferson is going to talk with us about medical and consumer debt, LFOs, and judgments for trans folks. And then Danon is going to talk with us about bankruptcy, the basics of bankruptcy, particularly as they impact LGBTQ plus clients. Each of these sections will be about an hour or a little less, and we will be taking 5-minute breaks in between each transition point to allow us to use the restroom, grab something to drink, take care of our bodies. I know we're all really familiar with Zoom fatigue these days, so I really encourage you to take those couple of minutes to stretch and keep your body and your brain healthy. Al, can you bump us forward? Thank you. So I'm going to start us off with a land acknowledgement to ground us today. At Q Law Foundation and in all Q Law Foundation activities, we acknowledge that we exist and do our work on the traditional land of the Coast Salish people, which is the traditional home of all of the tribes and bands within the Duwamish, Suquamish, Tulalip, and Muckleshoot nations. We acknowledge not only their past existence, but their present existence, and honor them and the land itself with gratitude so that we can be here today doing our work. We also acknowledge the ways that the legal system that we are operating in today has historically and recently acted to strip Indigenous cultures of land rights, cultural practices, and family history. It's particularly important for those of us in LGBTQ plus communities because one of the effects of settler colonialism has been to rob Indigenous cultures of the gender expansiveness and gender diversity that has been part of those cultures since time immemorial. And we commit in all of our activities to be agents of change. Al dropped for us into the chat a link to Native Land, which is a really amazing, amazing resource that has been put together that allows you to look up a location and find out the traditional lands that that location sits upon. So I encourage everyone to take a moment, click on that link, look up either where you are, if you're joining us from Duwamish territory or other parts of what is now the state of Washington. Let us know where you're joining us from. And I like to use it just to look up a little bit of my personal history, right? Where were my family vacations taken? Where have I traveled in other parts of my life? And whose ancestral lands are those, to help learn a little bit of deeper history about the land that we occupy in our day-to-day lives. Thank you. And with that, I'm going to bump us forward and let Al kick us off, talking about an overview of LGBTQ plus financial health. Thanks so much. Take it away, Al.
Hi, everyone. Again, I'm Al Littlejohn. I use they, he pronouns. And Denise is going to do some behind the scenes so we can get this live transcription going for folks. But to start us off, I have the fun job of setting the stage with the good old depressing information about the financial overview of LGBTQ communities. So I think it's super important to first know if you're going to help someone, like you have to know who you're helping. So the first slide is going to be a general overview of what the LGBTQ communities in Washington look like. And then we'll move more into those various financial penalties faced by LGBTQ communities. A lot of different like topic areas are the same for LGBTQ folks as non-LGBTQ folks, but because of various forms of discrimination, this results in less income, more costs, and overall increased economic insecurity. Okay, so an overview and intro of LGBTQ folks in Washington. So about 5% of the overall population in Washington identify as LGBTQ. Generally, the US is 4.5, so we're about on par. When taking into consideration the number of adults who are in same-sex relationships, engage in same-sex sexual behavior, or are sexually or gender diverse, but do not publicly identify as LGBTQ for whatever reason, the number increases substantially, representing more than 10% of the adult population. So if you think you haven't supported an LGBTQ client, you probably have, and you just don't know for maybe a good reason. If you didn't know, Washington State's one of the top ranked states for LGBTQ equality with sexual orientation and gender identity protected under state non-discrimination laws. I know like before I came here that in a lot of places, Seattle is considered like a trans safe haven. I know I came from like butt crack, Kansas to come here and work, and I knew absolutely no one. And through my job, I supported trans folks who moved to Seattle just to be houseless because there were still more opportunities and it was still somehow safer for them to be houseless in Seattle than the other parts of the country that they were coming from. 29% of LGBTQ people in Washington identify as POC. This is in comparison to about 31% of non-LGBTQ populations identifying as BIPOC. 28% of LGBTQ folks are raising children. So sometimes when people think LGBTQ, they really just think about the good old G and think about two old white G's together with no kids and a bunch of extra money. In reality, that's not it. With that, 57% of us are under the age of 35, compared to only 28% of folks who are non-LGBT in the state of Washington. So what that means is we're young and we're broke. Best way I can sum that up. 25% of us are food insecure, meaning we don't have enough money to feed ourselves or our families. And this is in comparison to 12% of non-LGBTQ folks in Washington. So this is twice as amount. And these numbers also, I want to say was like before COVID happened. So also keep that in mind. And then finally, 22% of us, of LGBTQ folks, have an income that's less than $24,000 a year, while only 15% of non-LGBTQ folks in the state make under $24,000 a year. And a good reason for this is that many LGBTQ folks work in the gig economy, so they have short-term contracts, or they work in the top 5 industries that were affected by COVID, which is restaurants and food services, hospitals, K through 12 and higher education, and retail industries. And with that, 40% of LGBTQ folks work in those top 5 impacted industries, while only 22% of non-LGBTQ folks work in those industries. So again, our communities were more strongly hit when COVID came in. Now that we did a little quick overview of the community, we're going to move into those various forms of discriminations and other barriers that I was mentioning that increase financial burdens. So starting off with some good old employment discrimination. As a trans person, as a Black person, I know this very well, but big old thing that lots of folks have to deal with is discriminatory behavior from employers. So at work, this can look like harassment by coworkers or supervisors, including assault or like harsh words, derogatory terms. From a national trans discrimination survey, 78% of trans folks reported being harassed, mistreated, or discriminated against by an employer. I know I've been in workplaces where I was the only Black person, the only trans person, and anytime I asked any sort of questions, it was seen as a form of insubordination, which obviously made it very hard to work. And sometimes this can also look like, like very insidious things like, as queer trans person, you might be tasked with like the worst tasks or just super strange tasks. You may say, I want to only work these hours, and they always find a pile on more hours or always find a way to never give you the hours you're looking for. They'll find ways to make sure you do all the work but don't get no benefits. Or commonly folks who, are dealing like bartending or food service, etc. They have employers that don't defend them when they have customers that, are aggressive or discriminatory towards them. This also includes being fired from jobs ultimately, or just flat out being denied jobs. In between, low wide range, but in between 13 and 47% of trans folks reported being denied a job. Big example, especially with the firing, when COVID hit, Black trans people saw the highest rates of firing. We were the first ones to go in a lot of cases. And, of course, while there are protections now, that doesn't mean it's not happening. It's happening every single day. So some impacts of that include lower wages, obviously decreased income, as mentioned earlier. LGBTQ folks are at a higher rate of making less than $24,000 a year. And nationally, 15% of trans folks reported incomes below $10,000 a year, compared to only 4% of the non-LGBTQ population. This is, of course, is only made even more difficult if folks happen to be undocumented, since employers don't have to provide any like protections or benefits or abide by a minimum wage. And again, folks are already have a higher chance of working in industries that are low wage jobs, leading to also higher unemployment, of course, decreased income. This also means, there's no chance of you building a savings. Because of unemployment, this leaves open periods in resumes that can get questioned, or you can get questioned about previous workplaces. And because you have a history of a lot of short-term workplaces, that may look sketchy, so to say, and you may not have the sort of references that non-LGBTQ folks might have had from like a non-discriminatory workplace. And understandably so, because of this, lots of folks have workplace trauma. And in a lot of cases that can lead to LGBTQ folks, specifically queer and trans, Black, Indigenous people of color, specifically trans women and trans femmes folks, to have to move into underground economies in order to live and survive. And this includes sex work and selling drugs, which means there's a higher chance of police interaction. And if your employer does a background check, then because of higher chance of being profiled or having to engage in these economies, you're going to be dinged. As mentioned, reduce savings. When there's no income, the only option is to tap on the little savings you have. If there is savings, in most cases, there aren't savings. So most people have to or turn to credit cards or like payday loans, etc., furthering those financial burdens. There's higher medical related costs, which increases our costs. Many folks depend on their employer for insurance. So you also have to navigate that if you are not employed, then the sort of things that are covered by state insurance versus private insurance, especially if you're moving in a state where Medicaid doesn't cover transition related care because of whatever reason they're considering it not medically necessary. And even with insurance, again, things that are transition related, like private insurance, they may still not cover that, which means that not only are you going to have to pay for insurance that does not cover a lot of the care that you need, but then you have to pay out of pocket for those procedures that are not covered. So again, forcing people to rely on credit cards, or in a lot of cases, crowdfunding. With COVID, people have been depending on mutual aid, and I have seen, I mean, again, even before COVID, people were seeing people crowdfund to cover medical costs. Because of employment discrimination, there's also less access to leave, decreased income. LGBTQ folks, specifically folks of color, report having less access to paid or unpaid leave, like leave at all. And for those who do have access, they really can't afford to take the time off, which also means that there's a good chance that there's increased costs for caregiving for whoever in the family is sick. For housing discrimination, includes discriminatory behavior from landlords, but of course this can also include having to navigate dealing with like discriminatory roommates and even neighbors. LGBTQ folks see that, you know, at a higher rate, they are denied housing opportunities. Through the national survey, 20% of trans folks reported being denied housing because of their gender identity. As an LGBTQ community overall, we're at a higher risk of facing eviction due to our sexual orientation or gender identity. 11% of trans folks have been evicted because of their identity, and 40% of trans folks reported moving to less desirable places because of anti-trans discrimination, and that this was even higher for people of color. Again, folks are, while they're not only denied housing opportunities, they're shown less options. And again, they're usually in less desirable places, but more expensive. Again, even with protections, this is stuff that we're seeing happen in real time. And again, if it wasn't for the moratorium, like it'd be Black trans folks out on the street first. Like again, even with the moratorium, I'm sure many of us have heard about LGBTQ folks and non-LGBTQ folks in housing where they're dealing with landlords who are trying to force them out. And of course, that is only heightened with this added layers of discrimination. So some impacts, again, longer, more expensive searches for housing, which increases costs. Again, folks are shown less options because of like gentrification, good old gentrification. City folks end up being pushed out, away from their community, away from resources and support, and which makes it less desirable to them. But again, because of gentrification, a lot of these like surrounding areas from the city are just as expensive. But there's also, I also want to note specifically for LGBTQ folks who are in rural places like rural Washington, Eastern Washington, sometimes rural LGBTQ folks feel like the pressure to move to urban areas in order to access resources or social programming or healthcare because they have one doctor in their town and they don't want that one doctor to know that they're HIV positive because that one doctor is connected to the one person at the church, to the parent, and all that good stuff. And when they're forced to have to move away from their home and their support, even if it's not a lot of support, that increases living expenses as well. And then also due to disproportionate rates of houselessness, in part connected to LGBTQ youth being forced out of their homes at a young age, folks have a higher chance of interacting again with the police, but also with the shelter system. Nationally, 29% of trans folks reported being turned away because of their transgender status. Good example from conversations that QLA had with different community groups. Folks don't want to be in shelters, definitely not during COVID, but even before COVID, nobody was trying to be in no shelters, which meant folks were choosing to couch surf with friends or family. Folks were living in their vehicles. People were sleeping outside. I have a good friend who chose to live in a tent out by like the river in Kent for 3 months during the summer, just because that felt safer to her as a trans woman of color than trying to be in any of the shelters. And that was after an experience of where she went to a shelter and someone had her ID, which did not properly reflect her gender identity, and they just stared at her and then we're literally like, we don't know what to do with you. Like, how do you stay at a place after having an interaction like that? And then with that, of course, another impact is higher loan and insurance costs. And Kim's going to talk more about credit discrimination, so I'll let Kim handle that a little forward in the future. Thank you, Kim. So healthcare discrimination. See discriminatory behavior from providers. 20% of trans folks have been refused care because of their identity. And for some folks who have been accepted into care, some providers have then refused to even to touch them, like as part of a physical or et cetera, because of their gender identity or sexual orientation, fears around HIV, et cetera, even though you think they'd be educated on that. Nationally reported 25% of trans folks have been harassed in medical settings, including having to deal with like physically rough or abusive treatment, especially if they are Black or Indigenous or people of color. I lost my spot for a second. As well as harsh language. There you go. Some examples of this is higher mortality rates among people of color who are able to become pregnant and bear children. Again, less access to like pain med and just being refused pain medication and having their pain just looked over or just like, yeah, rubbed off as not actually what it is. Folks then also just have the overlying discriminatory policies that target trans folks specifically. So I mentioned this a little earlier. This looks like insurance that doesn't cover care, which really just leaves us shit out of luck to pick up the tab. And transition related care can cost a lot of stuff. If you're going through a lot of gender affirming care to feel like your true self, like that can cost hundreds of thousands of dollars out of pocket because insurance doesn't cover that. And again, in some cases, like medical leave policies don't cover transition related care because it may not be considered medically necessary by an employer. And this leaves folks to have to use like unpaid sick leave or vacation time to recover as like personal time rather than being able to utilize paid family or medical leave. Some impacts of this are delayed and more costly expenses, increasing our costs. Again, due to various forms of these discriminations, QT BIPOC are more likely to put off seeking medical attention, which increases the chance of medical severity than needing emergency attention. And there's already higher rates of LGBTQ communities depending on urgent care and emergency rooms because of lack of insurance coverage. And with that, 50% of trans folks delayed preventative care specifically because of cost, and 33% delayed preventative care because of previous discrimination. Again, because of those discriminatory policies targeting trans folks, there's that long list of non-covered procedures, which increase cost. Again, as mentioning, transition can cost a lot of things, even if you are only just beginning like hormone replacement therapy, just doing that and getting some regular lab work can cost over $1,000 a year. And, you know, we're a state where there's legislation that is moving forward to make sure, like through the HCA, to get rid of the non-covered list, as well as legislation so that insurance providers can't just decide that transition related care is like cosmetic and not medically necessary. But a lot of folks live in states where that's not the case. And some folks even live in states where their state government is actively trying to deny them the possibility of receiving any form of care at all. And also because of this, as I mentioned, again, folks have to rely on credit cards or crowdfunding or participating in underground economies. And actually, like the number one, the top reason for engaging in underground economies is to be able to access healthcare and to cover healthcare procedures. And then another impact that increased costs is lost productivity at work and time away from work. As mentioned, folks may have to take more time to recover. Some procedures might be like outpatient, a little good in and out. Sometimes folks need to sit down and chill out for like a good month in order to like fully recover. And not only that, some people try to go through these processes and do this without notifying their employer because they don't want to risk their employer knowing that they're trans, right? So they try to like line up their paid time with like a weekend or like plan a vacation, do all the things to make it just seem like it was natural, like nothing happened, you know, there and back, and that decreases productivity greatly. And if someone just can't access it at all, that greatly impacts your ability to again show up at work and fully participate. And if employers do happen to know you're trans, like they might give you less hours or just like push you out because they see you as someone who's going to cost them more, but still, you know, like cost them more through like health insurance, but also that you have to take that time off. Also, they might have to now deal with other coworkers who are having issues with like your presence. And it's easier to just fire you than it is to fire the other 5 people who are being dickheads, etc. Overall, just to note, these experiences of discrimination require that folks either leave the situation voluntarily, which means risking like career barriers, taking on more housing costs, and etc., as well as requiring them to find a lawyer to pursue discrimination claims on a contingency basis. For most folks, this route does not feel accessible and is largely inaccessible for a number of reasons. I know myself, like legal system just feels gross. So it could be because of expense, it could be because folks don't know where to go for information or for a lawyer specifically. It can also be because folks have worked with a lawyer before and had negative experiences, or been in the court before and had negative experiences, as well as it just taking a shit ton of emotional energy and time. And for a lot of folks, it's easier to just like roll with the punches and keep going because you have rent to pay and you have to eat. So some barriers to identity documents. Lacking access to identity documents has some very large overarching effects. Some just can't afford it, similar to gender affirming care. Uh, Amending your identity documents, all of them can cost a pretty penny. Especially if there's like more, like there's things I wasn't even thinking about having to update. Like if you are like a homeowner, like on your mortgage, on insurance, all the stuff I don't have, that's all more stuff that costs to update. Nationally, 21% of trans folks who transitioned were able to update all their documents, which is surprising to me. But with that, 33% hadn't updated any of their documents at all. And in part of this is because some folks live in states where they can't amend their birth certificate or have issues amending other identity documents. And of course, this can be a substantial barrier. Folks have to use a birth certificate for something, and or they might get like dinged because of the gender incongruencies or name incongruencies. And with this, every single time you have to pull out identification that does not properly reflect who you are, you get outed. So this is getting outed to landlords, potential employers, police that can escalate the situation, and that's dangerous. For incarcerated folks, this process is even more daunting. From what I know, is even like after they've had their court order name change, because of their sentence, they're required to still wear their name tag with their previous name, and all their stuff still has their previous gender because they're told they have to finish their sentence as they came in, even though they are not. Well, they might be the same person. They have gone through a long journey to get where they are, and rightfully deserve to have their identity properly reflected, especially if it's recognized by the court. Example of, while it might be legal, some folks may still have to deal with like individual harassment at the DMV. There are instances of like trans women being told that they have to remove their wigs, makeups, and accessories. And that's just dehumanizing. Some impacts to that is not only the emotional toll, but it's time consuming and expensive. I just looked this up today, but effective July 26th, it'll now cost $301.50 to change your name in King County. And that's because the auditor's fee was increased by $100. That's a lot. It can take months to years to get all your documents updated, especially if someone like just doesn't have some documents, is undocumented, might have dual citizenship, if folks are under protection services, they're minor, incarcerated, etc. And then other impacts of this is trouble accessing public assistance, decreased income. Because of this discrepancies, it can lead to delays in applications getting reviewed and approved, and it may just stop them from getting approved at all. And in part because of fear of navigating this discrimination that also discourages from people applying in the first place.
So Al, since you're at a breaking point, I'm going to interrupt for just a moment to do two things. One is give a 5-minute warning. And the other is we have a question from in the chat about whether you can use a GR 34 motion to waive name change petition fees. So GR 34 is General Rule 34, and it relates to being able to obtain fee waivers based on low income. And you know, I can kind of through this question to say I can give the sort of what we see aggregate level in the legal system, and then Al, I think if you have thoughts about what you've seen in community experiences trying to ask for fee waivers for name changes. What we have seen on the aggregate level is that the courts will sometimes, there's a lot of inconsistency in whether courts will grant waivers for name change petitions. And I have heard clients report everything from the judge wouldn't do it because they said it's only for emergencies, and not seeing a name change as an emergency, or and also incorrectly believing that fee waivers are only for emergencies. They are not. And also courts not waiving the fees that go to the recorder's office or the auditor's fees. And the fee that Al was talking about just a minute ago that is going up by $100, it's going up from $103 in King County to $203. That is an auditor's fee that's a pass-through that the court charges and then pays to the county. And I think some of the courts have a perception, and I don't know that this is correct or not. I think that's sort of an internal thing to the courts that I don't fully understand yet, that that they feel like they can't waive that fee because it's not their fee, it's not a court fee. And so I think what that means in practice is that fee waivers are not not super accessible. I will also say I've heard from another legal services provider that serves youth that they have had difficulty getting the courts to grant fee waivers for minors getting name changes, and have not even been able to use what is sort of commonly referred to as the QLSP fee waiver, which relates to like being able to get a fee waiver because you're represented by a low-income civil legal aid provider. And the court's not granting those either. And we sent, in collaboration with a couple of other organizations, co-signed a letter to the district courts throughout the state asking them to please provide clarification on that. Al, do you have any thoughts on community experiences or community feedback? Thank you, Jefferson. Yes, QLSP means Qualified Legal Services Provider, and it's a designation for civil legal aid organizations. Al, do you have any thoughts on community experiences of trying to get fee waivers in the few minutes that we have left?
Um, I feel like the only people I know who have gone through the fee waiver process have been folks who have had support with lawyers who are also incarcerated, and that's why they were using it. Other low income folks generally just were like, it's not even worth it. And at the time when there were programs for financial aid in Washington, folks just like ate it because the financial assistance covered it for that purpose.
Right, so that was like social services organizations. And there are some trans supportive organizations that have had programs for financial assistance. And there it was for a while, it was through Gender Alliance of South Sound that they've recently changed their name. I feel like it's now, acronym is now DASH, but Al, you might know. Um, but they have had a name change petition fund, and and there were a couple of other programs that I don't think are still running now. But yeah, so that's sort of the coverage, is that there have been a couple of organizations that have either crowdsourced funding, and that's often a way that community handles it, have used other methods. But Al, you want to wrap up with this? I think this is your last slide, right?
I have 2 more slides.
Oh, two more. Okay, well then I will stop talking and let you go.
Okay, I will try to speed run through this. So the next one's lack of family recognition. While same-sex marriage is legal, it's not always a route for our communities. In order to access a lot of benefits, you must be legally tied to each other. And for some family dynamics, this doesn't just look like two individuals. With this, folks also have to establish rights and like legal rights over children in comparison to biological families. Again, this is where things could get more complex. Our families for a long time have been chosen for many reasons. And because of this, there could be multiple people again involved in a relationship, thus meeting a multiple parent adoption, or there might be multiple parents involved because there are donors included. And of course, like court costs. So this increases costs. The straights don't got to do all this. Some impacts that come with that is like if there isn't legal like parentship, like the right word for that, you might have to use or like pay for health insurance for your child or your partner. If you don't have like legal rights over children, you might not be able to claim children for tax purposes. And what we see is that kids of colors have a higher rate of being raised by someone who's like a relative or close family friend rather than a parent or biological parent. Because without having this sort of thing established, there's less financial support following a loss because there's an inability to access inheritance. And again, without that, that legal right, folks might not be able to fall under certain definitions of like family or households for various programs. And finally, where it all starts, unsafe school and educational costs. So a big thing to name is the school to prison pipeline. This is higher for LGBTQ folks and BIPOC students, and with police on site at some schools, this definitely increases the chance of these students having negative interactions. And this is whether from the individual, this is due to violence on their part, due to the traumatic ass shit that they've had to go through in life, or because they're on the other end of this and they're defending themselves against transphobic people or transphobic students, transphobic staff. So, you know, school's a traumatic place for a lot of people. With that as named, there's discriminatory behavior from staff and students. LGBTQ folks experience higher rates of bullying and harassment. GLSEN put out a report from 2019 saying that 86% of LGBTQ students experience harassment or assault, and they often experience staff not utilizing the correct name or pronouns, with 14% hearing school staff, or 14% saying that staff intervened when hearing homophobic remarks. That's only 14%. While there was 28% of students reporting being prevented from using the correct bathroom. So that's for trans students. And with that, again, even with protections, Q Law has had recent conversations with community where trans youth are having issues accessing bathrooms right now in Washington. There's also lack of programming without having GSAs or other affinity groups. This diminishes chance for community building and increases isolation. 78% of students reported avoiding school functions and 72% reported avoiding extracurricular activities because they felt unsafe. And this isolation we saw was only increased when students were having to be at home during COVID. And then of course, there's lack of familial support. So students may be forced to stay in the closet until they go to college or stay in the closet in order to get financial aid from their parents. And some LGBTQ students may choose to go to schools far away from their abusive families, compromising the fact that they're gonna have to pick up a lot of debt because of that out of desperation. And without going all into it, that leads to lower graduation rates. Folks are missing school. They don't want to deal with harassment. They have to transfer schools. Things don't transfer over, like credits, got lower grades. That leads to higher rates of unemployment, of course, lower earnings. And then if folks are able to continue on to higher education, again, there's those higher education costs, not having the familiar support, and specifically for trans students, the FAFSA paperwork is awful. And FAFSA matches up with Social Security. So if there's incongruency on their identity marker, that can hold the student up from getting aid, or can just, they might not get the aid at all, or it might like greatly delay when they get that aid. And that's going to have very large effects. And now I get to pass it off to Kim, but I think maybe we're taking a break.
Yeah, we're going to take just a quick 2-minute break to give everybody a chance to stretch your legs, get a drink, have a quick bio break before we move into credit discrimination. I do just want to remind everyone, please do drop your questions into the chat and we will lift them up to the speakers at any point in the presentation. We don't have to wait to the end of a particular session. We want to be able to kind of answer your questions in real time because this is pretty dense information. And I think the only thing I'll say is, as we head into this break, is to say that in light of all of these statistics that Al covered for us, the existence of our queer and trans communities is miraculous. Our folks are beautiful and resilient and creative, and in a lot of ways are navigating these systems with a dexterity that I think is impressive to me as a lawyer. And it's also important for us as lawyers to know how to help folks navigate the windows in the system that exist. So thank you, Al, for all of that really deep information and for that really clear picture of what our communities are facing. So we're going to take a quick 2-minute break and we will come back with Kim's presentation on credit discrimination. Thanks. Hey, Kim, are you feeling ready to get going?
Yes, can you hear me?
Yep, we can hear you great. And if your slide deck is ready, then I think we are ready to go. Attendees, don't forget to go ahead and ask any questions in the chat. And if you experience any issues with the closed captioning that you need, please message me directly and we will help you troubleshoot. Take it away, Kim.
Yeah, let me just make sure that I am sharing my screen. Is that moving when I click? On the
Sure
next slide?
is.
Okay, excellent, great. Well, I just wanted to thank Al and Denise for inviting me to speak today. As you'll see, I have a lot of biases about the issues today that I'm going to talk about today, and I don't hesitate to air those. Couple things I wanted to start out with before I get into the slides, and one of which is that while clients present to us with their individual issues and discrimination that they've experienced, this is all part of a larger system or systems. And many folks, um, BIPOC folks in particular, but not only, are at the intersection of several different systems that have existed for centuries, biased economic systems, systemic racism, and on and on. So I always like to think about the fact that this is system driven. I mean, the second point is that, folks are experiencing credit discrimination oftentimes from a place where they already have less economic security and less economic stability and fewer resources as a result of historic and economic factors. That makes, this much more difficult. There's also when a person or if a couple or a family or two friends wanting to purchase a home, however folks align, when they are denied credit or discriminated against in applying for credit, that has an impact on the larger community. It's not just an impact on the individual. And the third general point I wanted to make is that despite the fact that I'm a lawyer, I become increasingly convinced as I wear my lawyer hat over almost 20 years now that the law really is not the only way to transform these systems. It's certainly not enough. It may not always be the best way. I think that, like so many things that impact our communities, we really need to think about transforming those other systems, and in the area of credit, eliminating these concepts like risk, which creditors talk about all the time, and getting away from this space where an individual is reduced to a number, the credit score, which does not take into account the complexities of who they are and their journeys and what they hope to achieve, what they're capable of achieving. So with that, I will start. Credit discrimination is alive and well. And I dug into some of the statistics, and Danon actually forwarded me some interesting information. Thank you, Danon. One example is a recent study that looked at discrimination in mortgage approval rates for same-sex couples. And this was a study that focused on lesbian and gay folks. I didn't see anything in the study that flagged trans folks in particular, but what these social scientists found was that the loan approval rates for same-sex couples were 3% to 8% lower than for straight couples. And this was a study where they were controlling for income, they were controlling for the type of property that people wanted to get the mortgage for, they were controlling for different lenders, underwriting standards, and you still saw that high incidence of denial. You also saw higher fees. People are paying higher interest rates for their financing. And you're also seeing more instances where people, again, controlling for all these other factors, were required to have co-signers. So this type of discrimination is alive and well. You can say the same thing for credit card companies, auto loans, small business loans, private student loans, all different types of extension of credit. I wanted to flag some of the reasons why this credit discrimination continues to flourish. And one thing is that we have a lot more data now about people's perceived or actual sexual orientation and gender identity. Um, if you think about it, every time you purchase something online, every time you participate in social media, the groups that you participate in on Facebook or other social media sites, what you're buying, who you're buying things from, that all goes into the mix of data that's available about all of us. Does this show up in credit reports? Not directly. Do lenders have access to some of this information? Absolutely. And even when it is inappropriate and illegal to access information, that's all the information that's out there, we know that this still happens. And so even someone who is exceptionally private, does not disclose their sexual orientation or gender identity to the extent they can because of very real fears of harm and discrimination, just by virtue of how they participate in the economy and especially in the virtual world. That information is out there. So there's a lot more data to access. This is also an exceptionally profitable industry, and data collectors create markets where previously there wasn't a market. I have done a lot of work and continue to do so involving people with a history of criminal legal involvement, people with records, and how that information is tracked and used to discriminate against folks. And back in the day, before the technology we have now, sure, landlords could ask about someone's arrest or conviction record. Landlords, if they really wanted to, could go to the courthouse and look up those records. Now it is so much easier. It's so much easier. All a landlord or an employer has to do is pay some money and get a report that draws from all kinds of public records. And you know uh, yeah, it's a money making industry. And again, this availability of data provides a new avenue for bias. Another reason why there continues to be a lot of credit discrimination against queer folks is that I would say that government and corporations are several steps behind where they're at with respect to even acknowledging, like, for example, employment discrimination. It's still rampant, as Al pointed out, but we do see some even token acknowledgments that it exists, right? But there has not been as much acknowledgement by the official systems, government, economic systems, that credit discrimination exists. It's not as interesting to people. It's not as sexy. It's not as easy for a company to address as saying, oh, yes, we're going to try and hire more queer folks. You don't see a lot of companies saying, we're going to make sure that our financial products are accessible to people. You just don't see that. Some of the types of credit discrimination, as I mentioned before, denial of credit and loans, including home loans, higher rates, additional fees, lower credit limits, higher down payments, requiring a cosigner, which, for a lot of folks, if the bank says we're going to need a cosigner, they're looking around at their family and their friends and their community. And those folks are in the same situation they are, right? They've been denied credit because of discrimination. They don't have, a history of economic stability and economic security. So where is this cosigner? Right? The person that the financial institution is going to say, yeah, this person's a great cosigner, they are just not there. So those are some different types of credit discrimination. I wanted to talk about the laws that are available to protect clients. And again, emphasize, as we all know, just the fact that there is a law out there doesn't mean that employers and credit institutions and everyone else is not going to discriminate. With respect to federal law, um, part of the problem with so many of our federal, I think all of them actually, federal anti-discrimination laws, whether it's Title VII or the Fair Housing Act or the Equal Credit Opportunity Act, as I've flagged here, amongst the list of protected classes, they do not include sexual orientation or gender identity. Sex, gender, religion, age, marital status, those categories are included. However, many of the courts have interpreted sex or gender as used in these laws to include sexual orientation and gender identity. And one of the very first things that the new administration did, I think it might even have been on the first day of the Biden administration, was issue an executive order. The bottom line being that in these types of laws that reference sex or gender, that does include sexual orientation and gender identity. Now, that is just an executive order. It doesn't mean that the law has changed. It is a step in the right direction. Who knows if Congress will take this as an impetus to finally change those laws? That's been on the table for as long as I've been alive, pretty much, and I haven't seen a change. But this is a positive step. And one of the things that executive order did was to direct federal agencies to create rules that address this type of discrimination. And indeed, that's what you're seeing. One of the statutes that has some protections for people is the Federal Fair Housing Act. It prohibits discrimination in residential real estate transactions, including mortgage lending. And the agency that enforces the Fair Housing Act, Department of Housing and Urban Development, HUD, has now issued an interpretive guidance indicating that they do consider sexual orientation and gender identity discrimination part of discrimination against people on the basis of sex slash gender. This statute, it's enforced by HUD. Quite honestly, I'm not aware of anyone who's had success when they've submitted an individual complaint on behalf of a client to HUD actually getting anywhere with that. I think where there's possibility for HUD making some change is that systemic change. Finding a landlord, finding a mortgage lender that is across the board engaging in discriminatory practices. And so to that extent, even if an agency is not able to or unwilling to advocate on behalf of an individual client, if the client is comfortable submitting a complaint, and I say this speaking as a former government regulator, it's really helpful to regulators to hear from people about what they're experiencing. When you go as a line attorney, when I was at the AG's office to get approval to pursue an investigation, it was really helpful if I could go to my boss and say, look, we've received 50 complaints about this company, look at these complaints, hear these stories, versus me saying, yeah, I think this company is really sleazy and we should sue them. So I do always encourage people, again, if the client feels safe doing so, to submit complaints. The second statute that does protect people ostensibly from credit discrimination is the Equal Credit Opportunity Act. And this provides broad discrimination by creditors in credit transactions. It's enforced by the Consumer Financial Protection Bureau, one of my favorite federal agencies, the brainchild of Elizabeth Warren, back when she was still just a law professor, not a senator. It was gutted by the administration of the former occupant of the White House. I will not say their name. But I think in the new administration, we're going to see a return to the CFPB as it was before, which is some very aggressive enforcement of consumer laws. And like HUD, the Consumer Financial Protection Bureau is also, they've actually not just issued guidance, they have issued a new rule, administrative rule, that discrimination in credit against folks based on sexual orientation and gender identity is discrimination under the ECOA, even though that statute doesn't specifically call out that type of discrimination. It is enforced by the CFPB. And like HUD, I didn't say this earlier, there's also private causes of action for damages, which, again, um, bringing these types of cases is really difficult. As Al pointed out, it's very difficult for people to find an attorney who will take these cases on a contingency fee basis. If folks do income qualify for legal services folk are strapped. I mean, like my two fellow presenters here, I can attest to the great work they are doing and the great work their organizations are doing, but without the funding, they simply cannot help everyone. So the fact that we have private causes of action to enforce these statutes for many clients, it means diddly squat. And that is a legal term, diddly squat. But still can be effective when sending a letter on behalf of a client, pointing out to a company, here's all the statutes that you have violated. And gee, wow, I've looked at your website, bank, and you have these statements on your website about how you're taking a strong sense against discrimination. Yet at the same time, the person at your branch has denied credit to my client. So that is often an effective shaming strategy. State law is better than federal law. Our Washington law against discrimination includes sexual orientation, and in that definition, it includes gender identity and expression. It is enforced by the Attorney General, as well as the State Human Rights Commission. There's also private cause of action for damages. It prohibits retaliation for folks who report these type of complaints. And what's really interesting to me, and I hadn't even realized this as an attorney in this space, the Washington law against discrimination has 3 different provisions that cover different types of credit discrimination. And often people think about this law as prohibiting discrimination in public accommodation or employment and forget about these other provisions, which are, first one, unfair practices of financial institutions. And this basically would bar discrimination based on a person's membership in a protected class, including our clients, when determining whether someone is creditworthy. The second one, there's a lot of overlap in these. The second one is unfair practices in credit transactions. And this prohibits denying credit, increasing fees, imposing terms, restricting the amount if the person is in a protected class. And the third one is specific to real estate transactions, which also includes title and mortgage insurance. Now, what's really interesting about these 3 provisions, the first 2 can also be used as the basis for a Consumer Protection Act claim, which is also a really great tool on behalf of your clients because it's another way to get damages under the Consumer Protection Act. You can get treble damages. You can get your attorney's fees. You can also get injunctive relief. But that only applies to these first 2, not to unfair practices in real estate transactions. I don't know why. It doesn't make sense to me, but I think it would be safe to say that if a client is being discriminated against in a real estate transaction, you could probably make the same claim with respect to at least credit transactions. I would make a run at that argument. And again, sending a demand letter or an angry lawyer letter to a financial institution or a lender, I always tell other attorneys, and y'all know this, just pile on those statutes, explain to them exactly how many laws they are violating in contrast to, what they claim they're doing. And that can be very persuasive.
Kim, can I ask a question?
Sure.
For the 3 protections that you were talking about under the WLAD, one of the things that I sometimes have wondered when I'm advising clients in the legal clinic or in private practice, where folks are saying, I you know, I think something wrong happened here. I'm not getting the thing that I need in this financial transaction. How do you determine that there's discrimination happening? Like, it's not like the denial comes, it's a little different than employment, whereas sometimes an employer will give you the gift of saying, we're firing you because of your protected class. But in these situations, it's much more obtuse than that, instead of, so I guess my question is, how do you suggest that attorneys, well, first of all, should attorneys assume or at least troubleshoot for discrimination when they're dealing with any kind of unfair practice or any kind of financial concern, consumer concern, and how do you get that information?
Well, one thing that I always do with clients who are experiencing some type of credit discrimination by a financial institution, for one thing, they can ask why they're declined. And of course, they'll usually get some relatively generic response. But what I would do is get the client's credit reports. And I'll talk about that a bit later. Folks can get 3 free credit reports a year, one from each of the major credit reporting bureaus, and go over that. And, if it's very clean, right, the client doesn't have like a long history of, defaulting on loans or credit, which is the rare person, but that's a way to eliminate some of those reasons and may support a claim that this is in fact discrimination. But, Denise, the question you ask, I mean, it's exactly right. You may have a lender who will say something to the client that is either very explicit or, you know, thinly disguised, such that you can say, oh yeah, that is a proxy for gender identity discrimination. That is a proxy for race discrimination. But generally speaking, the only way that you can prove this is to show that that lender has engaged in a pattern and practice, a systemic practice. And again, that is something that when representing an individual client, it's really impossible to prove, right? I mean, that's why there's a lot of class actions in this space. That's why there's a lot of, or hopefully more, um, government action in that space, because they have the resources to be able to ask for, when they file that lawsuit, ask for all of the information, over X number of years. So it is exceptionally difficult. And I won't
Yeah.
deny that. And that may be why we don't see a lot of, if any, case law on these provisions,
Mhm.
because how do you prove it? Right?
Right. Yeah.
Yeah.
Yeah. And I think, that, and folks often don't know that when when they're hitting a barrier like this, that there is the potential that it could be discriminatory. And I think there's a question in the chat that sort of asks to tease this out a little bit more in terms of figuring out what types of evidence helps demonstrate discrimination based on gender identity and sexual orientation, as opposed to discrimination based on credit score or housing history or other types of more allowable discrimination. And one example that comes to mind is, there was a case that made the news, not in Washington, but in another state recently, where a Black woman was in the process of refinancing her home, and had an inspector had to come by to kind of assess the value of the home, and she kept getting these really low assessments, and finally took down all of the photos that included herself as a Black person, had her white I believe spouse be the person who interfaced with the auditor of the home, and basically removed any indication of race from anywhere in the house, and the home's value improved dramatically. And I'm wondering, or it was her white friend's husband, thank you, Al.
Yeah.
Just like amazing. And I'm just wondering, how you kind of pull these threads apart, and if that's a tactic that you might recommend that we suggest to clients. I mean, as sort of a informal test.
Yeah, absolutely. I mean, that's exactly like the type of testing that, government agencies have done for years. You have a person of color calls about the apartment to see if it's available. Oh, yeah, it is. You have great credit. Come on over and see it. They show up. All of a sudden, the landlord's like, oh, no, I just rented it to someone, or, oh, it's not available for rent. Next day, white person calls, goes through the same drill. Landlord says, yeah, it's your apartment. So yeah, I think that, some sort of informal testing, carefully tracking what goes on. One thing that I've thought about, I mean, so much of what happens now in applying for loans is online, right? You may not even have a phone call with a human being. You may not even have an in-person meeting with a human being. And I'd be really curious to know if anyone has done a study, if as like mortgage lending has shifted to interactions where there's no face-to-face or even like phone call type encounter, whether the rate of discrimination has changed. Or, in a situation where often what happens applying for a mortgage in particular is submit every piece of financial information about yourself online. And then they're like, oh, preliminary approved, come in and talk with us, right? Come and have coffee with us and talk about your options. And that can be, if a client comes to me and says, yeah, everything was great, and then they talk to me and nothing different came out in that conversation. They didn't suddenly say, oh, whoa, there's a bankruptcy. And we were just chit chatting and it changed. That to me is persuasive evidence. Um, so yeah, that's thanks for that question. It gives me a little more hope than my cynical mind had coming into this.
We love hope.
We love hope. We do, don't we? Yes. I see I'm getting close to my end of my time for this presentation, but I'll quickly go through the last couple of slides here. The Washington Fairness in Lending Act, it's not a statute that people can privately enforce. It's enforced by the Washington Department of Financial Institutions. Generally, it just prohibits financial institutions from using lending standards that, quote, have no economic basis. So it's kind of a backdoor way. It's kind of a anti-discrimination law that isn't explicitly an anti-discrimination law. I don't know how far that would get you. I know some really great people at the Department of Financial Institutions, but I don't know the resources they have that are committed to combating this type of discrimination. Let's see. I think this is my last slide here, second to last slide, and folks will get a copy of this PowerPoint. I've put up where complaints can be filed with these different government agencies. If your client is in Washington State, as presumably all of them are, I would actually try the first one first, the Civil Rights Division at the Attorney General's office. And yeah, I'd probably go that route rather than the federal agencies, just because we know that at least on the face of it, our Attorney General's office is purporting to support our communities and has in some instances. I put some practice pointers on the last page, which are things that I would tell clients in almost any type of anti-discrimination case or any case really, just always asking the client what the goal is. And sometimes their goal isn't something the law can't get them there. I also ask people, perhaps not using this language, but what are you afraid of? What are your concerns as you go through this process? And sometimes they usually won't say it. I can sense that they are afraid of me as a lawyer because even though I know I'm a nice person, I am representative of every person in the legal system and every institution that has done them harm. And so, that's something to identify. Obviously, encouraging people to put everything in writing, describing those interactions Denise talked about, the date, the time, who they talked to, what was said. I also always advise clients that if they're making a complaint to a government agency, that becomes a public record. It doesn't, their financial account numbers aren't going to be released, but if someone wanted to do a public records request, say to the AG's office and say, every complaint you received regarding sexual orientation, discrimination in mortgage lending, whatever, that complaint with their name on it is going to be released in response to that Public Records Act request. So I tell people that, some people, because of privilege, don't have a problem with that. Other people, again, it is just another way where the government is potentially or actually, doing them harm. So, the final point is, thinking about alternatives to litigation. There's a lot of community work, a lot going on before COVID, a lot of it because of COVID, as Al talked about, around these issues. There's advocacy by non-legal organizations that's going on. There's direct action. I just always tell people, let me talk to CULA, let me talk to this community org. Gee, maybe Al knows of a group of folks that are working on these issues. And even if, we're not going to share your client's personal information, we can get an idea of the type of work that's going on. We can get an idea if there's a bank out there that might be better, a credit union, that might actually look at you as a human being, as a person, and not just as a number. And, another tactic is publicity, press, social media, again, something to, talk with your client about, their comfort level. And I talked earlier about the power of shame. I probably should think of a better word for that. And I'm thinking about shaming institutions. I'm not thinking about things that will, make our clients increase the shame that they may already feel. But, someone comes to you and says, XYZ bank denied me a loan. Look at that bank's website, because I would bet you in this day and age, they're going to have stuff all over their website, Black Lives Matter, Trans Lives Matter. Here's the corporate initiatives that we've put in place. Here's our new values. They're probably not putting those into operation. And what your client has experienced is evidence of that. And so again, in demand letters, I always like to, hey, I understand these are your values, but look what happened. This is illegal. Here's all the laws it violated. What the fuck? I mean, no, I wouldn't say WTF, but that's the story you want to tell back to them. And Denise and Al, I don't know if you wanted me to just go right into the next.
No, go ahead and roll on through.
Okay.
Yeah,
Okay.
we will take another break for attendees who may be wondering when they get a bio break. We will go until 10:45 and then we'll take a 5-er.
Okay. Thanks.
Thanks, Kim.
Yeah. So this topic, credit reports and gender transition, I'll preface it with, I was struggling to find some hope here. I was depressed. I was depressed before I dug into this topic. I was more depressed. I mean, I'm sorry. I gotta say that, right? But I've seen some signs of some hope. I see some change starting to happen. So hopefully the next time someone gives this presentation, it will not be as depressing. What I want to do is, especially for folks who don't work in the consumer space, is kind of go over a bit and talk about some real basics, what a credit report is and what's in it, before talking about some ways to advocate for clients, because just understanding how this system works helps people issue spot, and helps folks kind of understand, what is, for lack of a better word, a legit type of distinction that credit reporting agencies are making and what is not. So, what is a credit report? Well, it's a report with information about a person's credit and loan activity and other financial information. So I pulled mine the other day because the state had told me there had been a data breach and my identity might have been stolen by, someone who tapped into a Department of Employment Security. So I pulled my report. There were some errors, but it had every single credit card that I had gotten back to when I was like, 20 years old and got a credit card with a $200 limit and like a 28% interest rate. And it was astounding to me. It had all of these accounts. And so, that is what it's in it. As we all know, this is something that lenders and creditors, potential creditors, landlords, often employers use to assess risk and for background checks. There are three major credit reporting companies, and sometimes they're referred to as credit bureaus, consumer reporting agencies. The big three are TransUnion, Equifax, I never know how to pronounce that, and Experian. So this is one of the hopeful things. I was poking around in their website and just trying to cut through, the rhetoric. And Equifax, I was impressed because they actually explained to folks who had changed, their name, and explicitly mentioned in the context of trans folks, not just, a cisgender person who got married and changed their name, but they called this out and they actually walked through, here's what we need from you so we can take your dead name off your credit reports. I was really impressed by that. Whether that actually works, I don't know. I'd be very interested in hearing back, from someone who tries to do that with that credit reporting company. I didn't find anything indicating the other two are taking those steps. There's a lot of rhetoric. But one thing that I've thought about as someone who now represents a lot of businesses in my practice is encouraging them that when they are doing credit checks for whatever reason, go with this company, right? This company is, at least claiming that they are engaging in practices to combat discrimination. Where does this information come from? Well, it comes from creditors. Your credit card companies, if you have a credit card, are reporting every month. Uh, Public records, they'll look at, if there's bankruptcy, if there's a tax lien, if unemployment security says they overpaid and they come after you. And of course, you can't pay it because of their mistake. It's like thousands of dollars. Not that I'm biased, but in any case, all of that stuff is public record, and credit reporting agencies draw from that. They also draw from government agencies. One source of information that folks often don't think about is if someone has been ordered by a court to pay child support and they have not paid it, or they're behind in their payments or haven't paid the court ordered amount, the credit reporting agencies will have that information. So that, that goes into the mix. And so, breaking down, more specifically, here are the things that are in that report. And, for our purposes, that first category, the person's name, this is really important to understand. The credit report is going to have any name that person may have used in connection with credit, including initials, including nicknames, including name changes for whatever reason the person changed their name. I've looked at mine. It has Kimberly Gunning, it has Kim Gunning, it has Kim L Gunning, it has KL Gunning. It has like every single permutation of my name. In the past, it has had misspellings of my name. And this is, a barrier and a problem for trans clients, because getting their dead name off their credit report in many ways is going to be a losing battle, because we have an industry, again, that is going to put nicknames and initials and other correct variants of folks' names. And so they're very loath to take that off of the record, which is kind of ridiculous because they have the person's date of birth and social security number, which is the best way to track people, right? I mean, there are a lot of other Kim Gunnings out there, as I've discovered on social media. I don't think any of them have the same social security number. And maybe somebody has the same birthday as me, but that's how you should track me, right? Not by, I mean, yeah, anyway, you know what I'm saying. It'll have information about the accounts, the type of account, the limit, the payment history, if it's closed, these public records I talked about. It'll also indicate every time someone has checked your credit. So if someone tried to buy a car and applied for an auto loan, it'll have that on there. It'll often have inquiries from creditors, and your client may say, I didn't apply for a loan from these people. Why are they looking at my credit? Well, they're looking at your credit because, they want to target you for offers of credit. So that can be very, very useful information. Common problems with the credit reports. Again, we have a lot of misspelled names and addresses, multiple entries for the same account. I'm pretty sure Jefferson's going to talk later about debt buyers and how debts get bought and sold just like any other commodity. And as a result, the same debt may turn up twice. What I call mixed files, which would be, let's say me, Kim Gunning, I've got my Visa, I've got my MasterCard, I've got my other loans. And then there's, say a Target credit card shows up on there and I'm like, wait a minute, I don't have that. Well, it turns out there's this other Kim Gunning out there and all of their credit is somehow mushed into mine. And it happens. It happens all the time. It is shocking how often this happens. Paid off accounts listed as open is huge, which is why I will always tell clients who are trying to, quote, clean up their credit. I hate that word, but correct their credit, make sure that it's accurate, is when you do pay off that account, get something back in writing acknowledging you paid off that account. And especially true if a credit card company says, hey, you owe $1,000, but if you pay us 800, we'll consider this settled. They're offering you that kind of settlement, or your client that kind of settlement, and you pay it, get something in writing, because otherwise it could very well be that the credit report's going to reflect, that remaining $200 that they said you didn't have to pay. The protective statute here is the Fair Credit Reporting Act. The point is to ensure that your credit reports are accurate and that information that should be private is private. Covered consumer reporting agencies besides credit bureaus, it includes tenant screening services. I don't actually know what a medical information company is. Jefferson may know when he's talking about medical debt. I was not clear what that was. I assume that the information that's shared is information about medical debts and potentially health insurance, not actual health information. But anyway, that's in the statute. If the Fair Credit Reporting Act is violated, there's, damages, quite hefty damages and attorney's fees. This is a statute where two federal agencies share enforcement authority. And I should also say there's a Washington Fair Credit Reporting Act that is very similar to the federal one. I didn't have time to parse through that, but it is out there. A lot of people have heard about the 7-year rule. And this is a rule that after 7 years, certain things cannot show up on your credit record. Is the 7 rule always complied with? No, it's not. And this is another reason to check those records, often because, a date is transposed. So, you're like, I know that, 7 years have passed, excuse me, but because they got the date wrong in the first place, they're not listing that the 7 years has passed. So I'm glad that y'all are being provided with these slides, because I'm going to skim over some of this stuff, but it is here. Folks have some powerful rights under the Fair Credit Reporting Act. You have to be told if information in your file has been used against you. Now, the level of detail that you have to be provided is a whole other story. You have the right to know what's in there. And again, I can't stress enough, encouraging clients to get the free copies of their credit reports from all 3 of the big 3 credit bureaus and going over that with a fine-tooth comb You can get one free report a year from each of them. There are also instances where you can get a free one if someone took an adverse action, i.e. denied you credit, if your identity was stolen. I believe if you're on certain types of public assistance, you can get a free credit report. There are a lot of scams in this area. I cannot even tell you. When I was at the AG's office, we called them rescuer scams. And they say, hey, bad credit, let us help you. Get a copy of your credit report. We'll fix it. The only place that is legit that provides a free credit reports that is not a scam is annualcreditreport.com. There are websites that look like that and use some of those words. They are not legit. Please, if you come away from this with anything, annualcreditreport.com. That, and they're going to ask client for social security number, addresses they've had in the past, information so they can make sure it's the right person, right? Kim Gunning, who's asking for that record, and they don't give me the wrong one. But very, very helpful to look at those. And again, when the client has legally changed name and gender markers, pulling these reports can often provide a list of all the things, all the places where their dead name may be is, right? A list to go down and tick things off. You have the right to ask for your score. If your employer asks for it, you have to consent. You can dispute inaccurate info. They must correct or delete inaccurate or unverifiable information. But again, inaccurate does not include names that the person has legally been associated with in the past. I think that it should, but it doesn't. Another thing I like to flag for people is that while access to credit reports is limited to institutions that have, quote, a valid need, so, creditors, landlords, employers, insurers, there are what I like to think of as these sort of pseudo credit reporting agencies out there. And these are things like White Pages and People Finder and Spokio. If you ever Google your name, all of those come up, and they want you to pay for a report so you can, find information about yourself. They often say, find out about the person you're dating, their secret background. These are not credit reporting agencies. The information they have is usually out of date, often inaccurate. I have heard instances where, like mom and pop landlords, for example, rather than using an actual credit reporting agency like TransUnion, will just log on to White Pages and, or just Google generally, but like pay for these type of reports, which, they should not be doing that. It's, let's see.
Tim, I'm going to give you the 5-minute warning
Yep.
and also take a moment just to uplift what we hear pretty regularly at our LGBTQ legal clinic from folks, which is that you may encounter when you're talking with folks about their credit reports um, and things like the junk mailings that come out of a lot of these consumer reporting agencies, is how scary it can be and how frustrating it can be for a person who has paid so much money and worked so hard to change their identity in many different, in as many different administrative places as possible, and then continue to receive junk mail under their dead name, which in some situations can create really significant safety concerns. Even going beyond the sort of personal impact. And it's pretty regular that we get requests at our legal clinic for, how do I stop this junk mail from coming to me in my dead name? I don't want my roommates to see it or my neighbors to see it. One person, actually, this isn't just one person, several people have over the years asked me, how do I declare my old self dead? Because they're so frustrated with trying to sort of tamp down the sources of this information. So I think really, you know, following these step-by-step processes for identifying what's in a credit report and really like doing as much as folks can to kind of tighten it up can help. But it is also just, you know, data lives a really long time on the internet, it seems like. So,
Yeah, no, absolutely, absolutely. Um, and just, really quick going through these steps again, get a copy of the credit report so you have a list of accounts to change and check for accuracy. Notify your banks and creditors directly. Also notify the credit reporting agencies directly. Supposedly, if a client tells the bank and the creditor, this is my legal name, they're supposed to tell the credit reporting agency. They don't. I would tell clients to inform the credit bureau directly. What is the person going to need to provide to the creditor or the credit bureau? Something with their name and their social security number, meaning their legal name. So pay stubs often work, social security cards, something with the current address and name. Again, a pay stub. If someone's been able to successfully get their employer to align their pay stubs with their identity and their name, that can often be an easier way to do that. The court order, state ID with their name. Something that someone pointed out to me, which, I think depends client to client, is, in changing names on bank accounts in particular, think about having this period where they might have both names on the account, only if, sometimes, you get one of those class action settlement checks for like, $20, or sometimes some money might come from somewhere. And if the if the person's legal name is on their account and the dead name isn't, they may have a problem cashing it. So there may be a short time period, depending on the client's circumstances, where they may want to think about, being in that sort of, I guess, in between state. Again, as I said, will their person's dead name and name on the credit report? Unfortunately, for now, I think yes, there's no law requiring credit bureaus to remove. It's definitely an area where there needs to be a lawsuit or probably a legislative fix. Um, as Denise mentioned, are people still going to get credit solicitations directed to their dead name? Probably. Once the data is out there, it's out there. I think you can reduce, you can dispute, you can correct, you can notify, those national registries that you don't want, robocalls in this name, you don't want junk mail. You're not going to be able to get rid of it, but they may be able to reduce it. Um, and one specific question I wanted to flag that someone had mentioned is that the utility company won't change someone's name on the bill until the name on the deed to the home is changed if they own their home. And that's something that someone's going to need to do a conveyance and have a new deed. And I'm not a real estate attorney. I don't know exactly how that works. But that may be a pro bono service that folks who are real estate attorneys could look into and figure out, how to make that happen for queer folks who do own homes and want to take that step. I see my time is running out. A few things on my last slide. There is discussion of creating a public credit reporting agency to replace or supplement the private ones. Is a government agency doing something a business does better? Maybe. I don't know. Depends on who you are. There are also some credit card companies that are starting to offer these true name credit cards. I think Citibank is, but I looked at the fine print, and um, Citi pointed out that will continue to use your legal first name for certain communications. So they're telling people, hey, you can get this card in your name, even if you haven't legally changed your name. But at the same time, they're telling the person that they'll still use their legal name, which to them is their dead name. So I'm not really sure that the benefits of this for people who are privileged enough to be able to qualify for this card, I don't know what the benefits really are, but um, in any case, I've tried not to make this too depressing. I think this is a space where non-legal advocacy is really going to transform these institutions. And 45 is gone. We have some good people in federal agencies. We have, more important, the amazing power of community, as Al discussed. So next year, this is going to be a different presentation, right? All right.
I think
Thanks.
so. I love when we have to revise our presentations because things have improved. We are going to take about a 3-minute break, and we'll be back here at 10:50 for Jefferson's portion of the proceedings, which will talk about medical and consumer debt, LFOs. Those are legal financial obligations and treatments for trans folks. So take a quick breather, and we will be back in just a couple of minutes. Great. I think we are just about ready to get started again. As we returned from our quick break, I did just want to uplift something Kim pointed out in the chat, which is that there is some great advocacy at the moment regarding the impact of big data, credit reports, background checks, and other issues related to folks with a history of criminal legal system involvement. That's coming from What's Next Washington, and Kim dropped a link to what's nextwashington.org in the chat. And now we have Jefferson Coulter here to talk with us about medical, consumer, and court debt. Thank you so much, Jefferson. We are really excited to have you. And this part of our presentation will go until 11:45, and then we have another quick breather before we turn to Danon's presentation. Take it away, Jefferson. Thank you.
All right. Thank you, Denise. Before we get started, I just wanted to mention sort of the difference between disparate treatment and disparate impact. You know, that's something that we come around a lot in this type of work. You know, so disparate treatment, and there are much better civil rights lawyers out there than I am, but disparate treatment is that simply, you know, more or less saying that I'm going to treat you differently because of this class. You know, I'm not going to lend you money because you're a gay couple, or I'm not going to do that. I'm not going to hire you because you're a trans person. So that's disparate treatment. A lot of the data that we're going to show you, and I'm going to go over a little bit of it as well, just from the consumer side of things, it shows that there is a disparate impact. That's a more challenging legal standard to meet. It requires a lot of times statistical analysis by an expert. And even though there may be private causes of action, it might not be something that for-profit attorneys or non-legal services, I guess you would say, are able to engage much in. And that's really an area that needs some exploration. And I hope that those of you that work in discrimination law might think a little bit about disparate impact litigation in the future. All right, so medical, consumer, and court debt. Medical is basically just a type of consumer debt, but it has some special categories, and it's particularly important to the LGBTQ community. So I've sort of called it out separately, but the big two types of debt that I'm going to deal with are court debt, which are anything that's owed to the legal system because you were involved in it, which is very important to this community because we're disparately represented in the criminal legal system for a variety of reasons that Al touched on. Consumer debt affects everyone. So does it affect queer and trans people differently? It does. We have the information that shows that it does. Why it does is still something we're not entirely sure of, and the information isn't great. I can advance my slide. So, why take this queer eye to consumer practice? Queer and trans people are different and they experience things differently in the world. I actually had to take a step away when Al was giving his presentation because as a gay man, I experienced a lot of the things that he was talking about growing up in the 80s and 90s. So you might find that even if you're an ally, even if you're not in the LGBT community, you need to try to understand the different perspective of people coming from here that have experienced harassment and discrimination in their lives, because it may color how they're approaching your representation with them in a way that you might not really connect with. So it's really important to establish rapport with the clients that you're dealing with. And again, when we're talking about all of these surveys and all of this data, it's imprecise reporting. It's not great, but it's the best thing that we have right now. So it's all relying on people that are self-reporting their identities. And most of the surveys aren't looking, oh, and I'm just gonna let you know, Denise, I can't see the chat screen, so please just interrupt me or feel free to unmute.
Yep, I've got you covered.
All right, thank you. So they all require self-reporting, and they all ask different questions. Some of them are going to look at things from the perspective of only gender non-conforming people. Some surveys collect data only from lesbian and gay people. Some, collect from different things. They'll look at only sexual orientation and gender, but not necessarily identity or expression. So we have a lot of information that's sort of overlapping. It's imprecise, and the populations are small, right? We know that 5% of the Washington population self-identified in a survey or more than one survey about their sexual orientation. We don't have as good information about the trans community. We don't have as good information from people that don't want to self-report. You can figure out, number of live births in a county by the two categories of sex assigned at birth. You can get that kind of information. You could figure out in this household if two people were of the same gender. But the ability to get information about the community, again, is a function of discrimination. How much discrimination do you feel that you experience if you answer truthfully? I think we would find out that the numbers are larger. So again, I had a slightly different number that I got from Experian on the number of Americans that identify as LGBTQ. What I got is 5.6. And again, that's not breaking things up from, how many are trans, how many are bi, how many are gay, how many are lesbian. We don't know. But we do know the kids are queer than ever, so more. And are they queer ever, or are they self-reporting more because they feel more comfortable? Again, I like to think that it's because there's greater comfort in doing it, because it gives me a lot of hope. And we know that in that community, different people are having very different impacts in their lives. LGBTQ students, on average, have $16,000 more student loan debt. Why is that? I don't know. And then there's also, when we're talking about the consumer world, there's the idea of these queer dollars, that all, particularly straight white gay men like myself, have just a ton of disposable income, so we're very different from like straight men, for example, because we have so much income. It's not true. Again, this is coming from Experian's report, household discretionary spending. For every dollar a straight man has to spend, straight women have 92 cents, and gay men only have 87 cents of disposable income. So why is that? Is it digging in? Oh, and by the way, lesbians are the worst off of the bunch, because they, for a variety of reasons, have less disposable income. And I think we can all speculate into that. And we could speculate, oh, well, lesbian women in a household together have children, and that cuts down on their disposable income. And then sort of the intersectionality of the gender and the sexual orientation sort of has this follow-on effect. But all gay human beings and lesbian human beings do worse in terms of disposable income than their straight counterparts. And that's just a fact. And so what does that mean from the community that I look at? I am at Legal Services. I'm at the Northwest Justice Project. So we typically only are able to assist people who make up to 200% of the poverty line. And and I'll get into this a little bit later, but recently the Office of Civil Legal Aid or Assistance, I always forget what the A stands for, does a civil legal needs survey update of the low income community in Washington. And in 2016, they did an update of that. And so they did this update, and then after the fact, we went back to them, various people, and we're like, hey, there's nothing about sexual orientation, there's nothing about gender identity, there's nothing about gender expression. Can we get this in there? And they're like, no, we can't do that, but we can do a supplement. And we got some interesting results, but there's one thing I want to point out. The first survey was what was called a probability survey. So those of you who understand statistics and surveys, and again, much better than I do, probability is using a representative sample and all this sort of thing. The supplement was what's called a non-probability survey. So it depended on people like me to go and take these surveys to places. And I tried to be as neutral as I could, but within the community. So we have a survey of people that we pre-identified to take the survey. So it's not considered a probability survey, which affects the precision of the data. But what we do know in the consumer context is 17.5% of people in the LGBTQ community reported having trouble with collection agencies. So that's something that I talked about mostly in this presentation, because we're trying to cover a lot of information at a fairly high level. Financing a car was a big problem, and getting a bank account was a big problem. We know in the state of Washington that low income people, somewhere between about 5 and 20%, don't have access to any bank accounts. And that's a problem, I feel like, for a variety of reasons. Also, out of all the respondents, 37% responded that they were discriminated on the basis of their sexual orientation. This is statewide. And 24 based on their gender. Again, this was called the LGBT supplement, I think. But it did not ask about gender identity. It only asked about gender. So we don't really know what that means. But we do know that gay people are 12 times more likely to experience discrimination based on their sexual orientation. 64% don't feel like they could go to a court, and 70% said that when they went to a court, they were treated unfairly. So LGBTQ plus consumer issues or consumer issues, take it for what it is. Again, disparate treatment, maybe not, maybe lesser than we think. Disparate impact, definitely we're seeing that. And so again, I've divided into two categories: the consumer debt world and the various rules that govern those types of things, and then the court debt world and the various ways that you can approach that kind of advocacy. And any of these debts can affect your ability to get housing. Any of these debts can affect your employability. Any of these debts can affect your ability, well, maybe not all of them, but driver's licensing is affected by court debt, particularly tickets and fines. And we know that a lot of this can impact our emotional well-being. For example, if you can't get a housing or employment because of a credit history, in that, I feel like that's an important aspect, because when I was approaching getting this ready, I was like, what are legal issues to look at? And not every issue is legal. And as Kim mentioned, not every issue might have a legal solution, but there's a dimension to the person that you're dealing with who's in front of you. And you need to understand their experience so that you can help design a legal solution that works for them. So what tools are available to people? At the Northwest Justice Project, we maintain through our Washington Law Help team, washingtonlawhelp.org. And it has a variety of topics that it covers, primarily family, consumer, money and debt. I'm skipping one right now, but I'll focus on money and debt. And if you go, I always want to plug Washington Law Help because it's such a great resource. We still have attorneys in our program that use this every week when something new comes up to them. But everything's designed or meant to be used by a pro se person. So it's a great way to get a sense of what your legal rights are, what options might be available to you, that sort of thing. One of the publications that we have is Gender Market Changes, and it goes through the process for changing the primary sources of gender marker identification in the state of Washington. So I encourage you all to check out. That's actually in our civil rights / LGBTQ plus section of Washington Law Help. I read through it before this presentation. From my lawyer perspective, it was an easy thing to follow, but we sure would like to get some feedback. So again, are there consumer problems for queer and trans people? Again, it depends. Gender, sex, sexual orientation, identity, your background, all of these things compound on each other, as we saw with the experience of lesbian women compared to non-lesbian women. The name evaded me. So again, this is back to disparate treatment, disparate impact. If the law is facially neutral, is that a problem? I remember when we were talking about the marriage equality cases, the sort of the argument of the people defending it is like, hey, this law is totally neutral. It prevents anybody of any sexual orientation from marrying somebody of the same sex. What's the problem? Seems totally fair. So again, disclaimer, I work with low-end clients, and I have for almost 10 years now. So my experience is informed by dealing with that population. But again, the most common problems that we see have to do with harassment by creditors. So I focus there. And again, just underscoring the fact that the vast majority of LGBTQ plus people in the low income ones that rather don't feel that they can get a fair shot in court. And when they do go, even more of them confirm that they did not get a fair shot in court. So again, what are the kinds of consumer debt that we see most? So I'm going to divide it into sort of 5 key categories that impact our clients the most. And again, reiterating what Kim said, one of the best places to start with a client experiencing any of these sort of debt issues is to get copies of their credit report and go over them, as she said, with a fine-tooth comb. There might be other things that just haven't popped up yet. So what defenses and strategies in all of those different consumer debt context do you have? What's sort of the common thing that you're looking at? And I'm happy to say that one of my colleagues who's an expert in this particular area is on here, and I expect that they will correct me should I make any errors. One of the cool sort of defenses in Washington, if you get to the point where someone is being garnished, is that you have protections for certain amounts of money in a bank account. For the 90 or 80% of our clients that do have a bank account and deal with garnishment. So $500 just is the sort of general exemption. But if somebody's trying to collect or garnish for a student loan, you can protect up to $2,500 of it. And for other consumer, and that's a term of art as defined in Washington law. I think it's anything for personal or household use, but don't quote me on that. It's worth knowing about the bank account garnishment exemptions. If somebody comes, these exemptions are not automatic. So you have to assist a client in responding to the garnishment claim form, or the answer form, I think it's technically called. This is important protection. Medical debt, as Al mentioned, particularly in the trans community, there are enormous medical costs that are not often covered, and that it varies. You can have a religious employer, and you might have a religiously sponsored health care plan. You might not be able to get the services that you need. There's different impacts for different types of things that you're doing. And there could be emergency cost, whatever. We know that this community has much higher medical debt. And one of the cool things in Washington, and I'm also in other states, I only know Washington, but here we have what's called charity care. And charity care allows for the coverage of medically necessary treatment, free or reduced charge for people, basically up to 100% of the poverty line. And I forget the exact number this day, but I think it's about 14,000 for one person. And then often up to higher amounts, but it might be a reduced amount of discount up to about 200% of the poverty line. And again, so they're required to do this to provide free services for medically necessary treatment. That generally means inpatient. So admitted to an emergency room, admitted to the hospital from an emergency room, something like that. Does not include outpatient, doesn't include a variety of things. I also don't think it includes urgent care, which might be a reason why we have more and more urgent care clinics. There is a really great portal maintained by the Washington State Hospital Association with all of the charity care programs for all of the providers in the state. Some of them do a better job at providing charity care and providing outreach and identifying what their policies are to people. Others do worse jobs. I remember I took somebody to Sacred Heart's emergency room here in Spokane a couple years ago. The first thing they did before they would let us in the lobby was find out about our insurance. I don't know if that's okay. So know about charity care if you're dealing with somebody, and that the time when the hospital has to determine whether they qualify is both at the time they apply for charity care and at the time they receive care. So there could have been one of those where they could qualify for some relief. And as to all consumer debts that are out there, particularly credit card debt, old credit card debt, charged off accounts, things like that, we want to figure out if somebody is a debt buyer. So if the person coming after you, or after your client rather, is a debt buyer, we have this cool statute in Washington that requires so a debt buyer is somebody who buys charged off accounts, uncollectible accounts, things like that for pennies on the dollar, and then turns around and sues somebody for them, gets default judgments, garnishes them, that sort of thing. And it's part of their business model. You're going to pay 6 cents for this account, and then get 100% of the value of that account, plus attorney's fees and costs. So it's an incredibly lucrative market. They're national debt buyers. But one of the problems with the debt buyers is that typically they cannot prove, they don't have sufficient evidence to show that the debt's good, that hasn't been paid, or anything about it. They can't submit an affidavit along with their motion for default that says that they can verify this is good data and this person actually owes the debt. So what RCW 1916-260 did was create specific requirements for debt buyers to be able to sue or collect to file suit rather, against people to collect these debts. And we believe that this is violated very often in the state of Washington. And that provides all sorts of great defenses for somebody being sued or being garnished. So I encourage you all to be familiar with the debt buyer statute in Washington.
Jefferson, we got a really great question in the chat, if I can
Yeah, shoot.
if I can interrupt you. And this actually goes back to your previous slide about charity care. And the question is, are clients able to apply for charity care after the provision of services if they didn't know to ask for it?
Yes. My understanding, and we've done this before, we've applied for charity care after there's been a default judgment against somebody and there's been garnishment. And typically what the creditor must then do is refund that money immediately if they would qualify for charity care.
That's great. Love a good, clear yes, no question. Thank you so much, Jefferson.
You bet. And again, I may be being held up as an expert, but I am a dabbler in all of these areas. So if anything I say is incorrect, I will take no offense if anyone corrects me. Student loan debt is such a beast of its own, right? It's generally not dischargeable in bankruptcy. And Dana will probably deal with that. But there are different kinds, right? There's federal student loan debt, and then there's private student loan debt, and those are probably treated a little bit differently. But most of it can be discharged if somebody is permanently disabled. So if you have a disabled client, somebody who's on SSI or SSDI, this might be an option that you look at. And I don't think a lot of student loan borrowers recognize this, but you can consolidate defaulted loans and maybe come up with some options. And that's actually could be a better thing to do. The National Consumer Law Center, assuming the person has the ability to pay, National Consumer Law Center has this student loan borrower assistance.org site, which explains the process, not from the the creditor's perspective, but from a legal services perspective about what rights people have, what the options are, that kind of thing. So if you're dealing with somebody with student loan debt, it's good to know about student loan borrower assistance.org. And generally, everybody should know about the National Consumer Law Center. They published a multi-volume treatise. You can get it online or offline. It's fairly expensive, but it's a cool organization to be a member of. Another big thing we see, and I think we're going to see a lot more of it as the eviction moratorium is sort of bridged out, is landlord-tenant debt. So what is that? It could be a couple of things, but primarily it's, when we think of it, it's an excessive damage charges. And the worst case scenario, it's excessive damage charges plus charges to renovate the unit. So somebody leaves the place, I left it so clean, and then they end up not getting their deposit back, and then they get billed for all of, thousands of dollars of, I had to replace the cabinets, had to put in new carpet, had to do all these sort of things. And typically, the only thing a landlord can take out of a deposit is, actual damages. Can't be ordinary wear and tear. Somebody lived there for 10 years and they said the carpet was destroyed. I mean, what's the value of a carpet after 10 years? Maybe nothing, right? So in those cases, you would want to get information about that and ask them about their depreciation schedule on their taxes, the landlord who's requesting that. But there are options there as well. But first order of business. Oh wait, stepping back. I mean, why are these landlord-tenant debts such a problem? A negative rental history is a typical thing used in occupancy standards. And negative means that they have an outstanding balance, whether it's BS or not, whether someone decided not to release an apartment to them or a house. It can be a variety of things. For both public and private agencies, they look at these rental histories as part of their admission standards. A large LIHTC or a low income tax housing credit, like low income affordable housing provider in the state of Washington, it's an absolute bar to any of their properties if you have any outstanding balance to a previous landlord. And unlike a criminal record or an eviction, which typically it's a ban for 3 years, if there's an outstanding balance, it's a perpetual ban. It never goes away. It doesn't have a time limit. And that can vary from person to person. But how do you approach this? Somebody comes to your office and they're like, hey, this landlord is saying I owe them, $1,900 or whatever it is, or $5,000, whatever the case may be. First thing to do is you got to wait 21 days, right? Because the landlord has 21 days to send you a statement about, again, forgetting the exact terminology, but basically, here's your deposit, here's what was reduced from it, here's the balance, and here are the reasons why. If they don't do that, they're supposed to have to give your entire deposit back. So if it's past 21 days, demand the return of it. If you're further on in the process and the person came and said, hey, my dickhead landlord never gave me my deposit back, and now they've turned this over to collections. First step there is, again, get the credit report, see if it's even on there, but dispute it with the collection agency and demand that they verify it. One of your rights under the Fair Debt Reporting Act or the Fair Credit Reporting Act. It's one of those. If it's even further along and you get a lawsuit filed against them for damages, again, just answer the complaint. This is something, particularly for low-income clients and people that might be traumatized by what's going on, they just try to forget about it. And sometimes we have to remember that as attorneys advising people in this space, trauma is a thing. It impacts the way people feel and it impacts their decisions. There's great research out there about how people experiencing trauma actually score lower on an IQ test than somebody not experiencing trauma, all other things equal. It's a significant barrier to people and it can't be understated. I'm doing good for time. So the other main types of debt that we deal with at NJP is what we call court debt. And those are basically in two different categories. So one is called legal financial obligations, which are imposed by superior courts. And then courts of limited jurisdiction typically have fines, fees, or particularly for municipal courts, tickets, speeding tickets, all that kind of stuff. So what are your primary goals when you're dealing with somebody who shows up? Hey, Danon, my name is so-and-so. I have, the Superior Court in Yakima County sent me this collection notice. I owe $2,700 for this conviction like 5 years ago. I can't pay it. The first thing you do is you find out why they can't pay it. And the second thing you do is figure out, based on their reasons for not being able to pay it, whether they can qualify to reduce or eliminate LFOs. There are statutes that allow people, again, lower income people, to reduce or eliminate a lot of their LFOs, including the interest, which used to accrue at 12% per annum. That's been eliminated for part of LFOs. And again, LFOs is restitution victims penalty assessment, a whole host of fees that are charged to you to fund the court system. Once you reduce and eliminate LFOs, the next thing you have to do for the client, and this goes to their credit reporting, is you got to vacate the conviction. And we'll get into that a little bit later. And then once you vacate it, as Kim mentioned, never trust the person reporting to credit bureaus or to any other agency to do the reporting. It's better that you do it. And then if they do it, great, then they've been notified twice. But better to do it twice than never at all. And Washington State Patrol here stands for, oh, I'm sorry, WSB stands for Washington State Patrol, and that's basically the collector of conviction data in the state of Washington. So again, what are legal financial obligations? Everyone who has any sort of felony conviction in the state of Washington, and again, Al talked about this a little bit, there is a lot of, I'll call it survival activities that are engaged in, particularly in the trans community and particularly in the queer community of color, which caused them to be subject to greater scrutiny by law enforcement and a variety of other things that they got into. That anybody, regardless of the crime, regardless of whether there was a victim, regardless of anything, gets charged a $500 user fee by the court system, regardless of their ability to pay. And that's not waivable or reducible. You got to pay that. We've tried over the years to challenge that. We haven't got there. There's some movement in the legislature to get rid of that. Didn't get there in the last session. And the reason this is a problem, particularly with people with disabilities who don't have the ability to pay, it means that they're under, for the rest of their life, debt supervision by the court. It means that case is always open. It means that always shows up as an active felony. And it will mean that person has to appear at least annually before the court for the rest of their lives to explain that they're still disabled and still too poor to pay. I think it's a big problem. There is the ability of the court, though, you can file a motion to suspend that payment. Or if you're feeling generous, you could just pay it for them. That's not really a resource we have right now. But you can file a motion to suspend payment, and then they'll basically take them off the docket for a while. And that will give them some relief and allow them to get some time away from whatever the experience that they had, which could be very helpful to people in their emotional well-being. We do have a proposed general rule 39, which is out for public comment right now. It was published by the Supreme Court, which will streamline the process for getting these waivers and reductions and suspensions when people don't have the ability to pay because they're homeless or disabled. And the reason this is important is because different counties, we have 39 superior courts in the state of Washington. They all do things 39 different ways. Some counties, if you don't appear, they issue a bench warrant for you. And then we have somebody, dragged out of, a Stoughton County to Whatcom County, picked up by the police, dragged to Stoughton County, dropped into Stoughton County in the jail, then they get released from the jail. And then they're like, hey, why didn't you pay this? And they're like, because I'm homeless and I don't have any money and I have, all these other things going on. And they're like, oh, okay, you don't have to pay it. And then they got to figure their way home. I mean, I once represented a client who was picked up in Whatcom County and transported to Benton County. And the client was picked up out of a nursing home. He was in an assisted living facility because he had a traumatic brain injury and then dropped in Benton County. It's a horrible thing. It needs to change. But this is the state of things right now. So I just want to stop for a second and mention State v. Blake. So State v. Blake, if you're not familiar with it, was a Washington Supreme Court that came down in February of this year, finding that the simple possession of controlled substances in the state of Washington, that law was unconstitutional and void. So every conviction for simple possession of a controlled substance in the state of Washington that happened prior to that date is void. So any of this has a tremendous impact on our clients, and it has a disproportionate impact, positive for a change, for the LGBTQ clients that you might represent. It means that you can go into court, vacate that conviction, poof, like it never happened, and the court has to pay back any money that they took from your clients because it was an unconstitutional statute. Now, this has created all sorts of chaos in the court systems because A, they don't have the money to pay them back, even though the legislature appropriated, I think it was 50 some million dollars. Still not nearly enough. And again, courts are funded by these. Superior courts get somewhere around 40 to 50% of their income from LFOs for their operating expenses. And this was the most commonly charged felony in half the counties for decades. All of that money is owed back to these people. And for those people, when they owed that money, lack of ability to pay was never an excuse. So I say, let's have a lot of fun with this. So what are the resources available to helping your clients, turn the tables if it's a Blake conviction? And what are the resources that are available to your clients that, have something else, a trespass, a battery, or whatever out there? Washington Law Help has sample pleadings meant for pro ses, but quite frankly, very good for lawyers too. I've used them for decades now, of all the details, including instructions for how to do a motion to remit. There's only a few relevant statutes that you need to be familiar with. The first one is out of the Sentencing Reform Act, and the other two have to do with execution of judgments and contempt. Just one step back. So the reason that there are these constant hearings for people that have legal financial obligations is because part of their sentence requires them, their judgment and sentence requires that they pay, as a condition of their sentence, legal financial obligations. So they might have spent time in jail, they might have spent time on community supervision, probation, we call it community custody here, and they've finished their sentence, but they haven't finished their judgment, and so that judgment is what keeps that case open. And the failure to pay that judgment is punishable as contempt in Washington. So that's why it presents such a problem for these people. There's some really great resources from the Minority and Justice Commission on this. The ACLU did some really great cases in some of the same counties I was working in. It's really an interesting, I've spent a lot of time on it, so I'm super passionate about it, but I'll move on. But I encourage you all to know the vast injustice that is our legal financial obligation system in Washington. Just a quick run through of what we tell people that are doing this work. So at the client intake, you're going to do whatever you need to do to establish credibility and rapport with your client. And then again, just like a credit report, you're going to run whatever reports ability that you have for the client, so you can find out, where their convictions are, what they were convicted of, and how much money that they owe. And it's always good, I think, to pull the judgment and sentence. That's essentially the order or the final judgment for a criminal case, just so you can figure out why they were assessed certain things and how much and how they got there. Were they charged for something higher and then that was reduced down and they pled to something lower? What were the reasons that they did? And then if they lack the ability to pay, you get proof of their income. If they get ABD, which is age blind and disabled, it's something a lot of people get before they qualify for Social Security insurance or disability insurance. And figure out if they're being collected from by the state, which is very common in most counties, or if they're being collected from by a collection agency, which is very common in South, Sound, Pierce, Thurston as well, I believe. And then go to Washington Law Help, get our motion to remit, file and serve the prosecuting attorney, appear at the hearing if it's required, and generally you'll get the relief that you want if you come in and you're an attorney. Our clients do not do so well as pro ses. That's another problem. But maybe that's why you went to law school. Next thing you do is you vacate the conviction. Just because you paid off the legal financial obligations doesn't do anything about the conviction. The conviction is still on their record. It's still being reported. It's all of these things. So in order to vacate a conviction, make it go away, They have to complete all of the terms and conditions of their judgment and sentence. And one of those conditions is the payment of LFOs. So you get rid of that, and then you have to get a certificate of discharge from the court clerk. So I invite you to talk to their clerks about all 39 of them have a different process for getting this. And then you have to wait a statutory period of time depending on the type of conviction that they had. For Class A felonies, you can't get rid of them, so don't even bother with it. For B and C, and Class A is the most serious class of felony. B is less serious. C is what these simple drug possession charges were. Don't have to worry about that anymore. You can get vacated all of those anytime. So you have to wait the statutory period of time to do it. And I did not give you the reference, but if you do a search RCW vacate conviction, it'll pull up the statutory reference for you, and just follow the statute. The other main type of court debt, particularly that our clients see, are from district and municipal courts, and they're totally different from LFOs, even though they function in many of the same ways. LFOs is a term of art defined in the Sentencing Reform Act. And even though they function similarly, there's no such definition for districts and municipal courts. So any judgment from a district and municipal court functions like any other civil judgment. It expires after 10 years unless renewed, and you can renew it and get an additional 10 years. So after 20 years, at least there's a light at the end of the tunnel for the poorest people. But the cool thing for the poorest people is that district and municipal courts will typically waive everything if there is a showing of indigency. But they won't waive traffic tickets typically in municipal court, because ability to pay has never before been a consideration. You know, hey, if you've got enough money to drive, then you got enough money to pay these tickets that you keep getting. So you get one ticket for your tail lights out. You get one ticket because you went 5 miles over the speed limit, you know, whatever it is, and they accumulate. When these people aren't able to pay those tickets, then the district courts used to foreshadowing, used to send notice to the Department of Licensing that was then required to suspend their license. And then they would end up picking up a driving with license suspended in the third degree, which is a criminal offense. And then they have a criminal record for being too poor to pay their tickets. Anybody heard about Pierce v. Department of Licensing? It's a big deal. So our friends at the ACLU represented some of NJP's clients in a class action lawsuit. I take that back. I don't remember if it was class action against the Department of Licensing. And the judge in Thurston County enjoined the Department of Licensing from suspending any licenses because the I'm gonna make a hash out of this. The license suspension statute is unconstitutional as applied to indigent people. So what did that do? It restored 170,000 driver's licenses. I mean, no biggie, it's just a thing.
Jefferson, we got one question in the chat that I thought was helpful, a helpful clarification. Is there notification given when a license gets suspended to the person holding that license?
I mean, assuming that their current address is on record with the Department of Licensing, they typically get a notice saying that it will be suspended in such a day, unless you do X, Y, and Z.
Great. So theoretically, assuming everything is up to date, but for populations that are moving a lot, marginally housed, et cetera, have some instability.
Yeah, we see a lot of clients who did not get the notice. And then of course, you know, you should have known that you got the ticket and you should have known all of that sort of argument. But again, intersecting that with, you know, the trauma and other things going on in people's lives, trying to get their kids to school, trying to work, you know, things happen.
Yeah, absolutely. Absolutely. And I will say from personal experience, I actually had a suspended license for several months without knowing about it because of that reason. I was not living at the address that was on file. This was like 20 years ago. Yes, I reported it to the bar. Because, interestingly, because of a speeding ticket that I had gotten and paid, and Thurston County had not registered that I had paid it. Like, it was just a clerical error. And so they suspended my license after sending me notice that I wasn't getting because I wasn't living there. And even though I switched states for my driver's license and switched insurance, actually, even though I switched insurance, I did not know that I had a suspended license until I went to switch states for my driver's license. So the insurer was like, you know, sure, you can get insurance in a new state, and had no idea that there was any problem with the license until I went to the new state, and they were like, you're not supposed to be driving for the last 8 months. So it can definitely be a rude awakening. Since we have a little bit of extra time in your section, I do want to invite folks to ask questions. And then Kim, I want to give you an opportunity, since you put a really beefy comment in the chat. I want to give you an opportunity to say that out loud, so that we can have it for the recording, and also so that folks can ask questions about it. But please do, we do have about another 8 minutes left in Jefferson's time. So please do ask any questions you might have, particularly as this can be a really thorny area, and it's an area where there's a lot of moving parts for our communities right now.
And I understand that this was a speed overview. So if anybody wants to dig in a little, I'm game. I thought I had to be done by 11:40, so that's why I was rushing a bit. And I can't see the chat, so I'm going to stop my screen share so you can see.
Did you want my beefy comment, Denise?
Go for it.
Okay. So one of the many awful things about LFOs and so-called public debt generally is that by statute, a collection fee can be imposed on the principal amount of the debt up to 50% of the principal amount, which is different than like a, consumer debt, debt Yoda, credit card, whatever, because debt collectors can't tack on collection fees. But this up to 50% fee is why debt collectors are really excited to get contracts with counties to collect LFOs. I mean, they're making money. And of course, with a really high fee, which by statute is, quote, presumed reasonable, even somebody with like $1,000 in LFOs, I mean, that's just going to go up dramatically. And this is something, when I was at Columbia Legal Services, we tried a few times to get legislation that would change this, but no luck. So, that's, yeah.
Kim, you'll be glad to know that the Alliance is still looking at this issue. It's still on our radar. We're still after it.
I know. Yeah. And also the other thing I should add is that if like the medical debt is owed to a public hospital, that's also considered a public debt. So these fees can be tacked onto that as well.
Yeah, thank you for diving into that. I think that, this is, I've been very happy to see the shifts that folks have been working so hard on with LFOs. I know it was a long conversation, and the Blake decision obviously was also a game changer for, for our communities. One thing I did also want to note, just related to the license suspension issues. It's not super related to consumer issues, but it does have an impact in this area. And since we have a couple more minutes, I can mention it. Just that one thing that we have learned about getting name changes with Department of Licensing is that if people do not also change their Social Security records at the same time, then DOL and SSA talk to each other and find a mismatch. And that mismatch will result in the individual's license being, it's not quite suspended. Al, maybe you remember the term that they use, but it's something more severe than suspended. So a person will get a notice saying your license is gonna go away, revoked, I forget the term, but unless you fix it, and the person then has to go to SSA and go through their process to update their records, which can be pretty onerous, particularly under COVID policies. And so that's been a pretty big bureaucratic hurdle Al just pointed out in the chat, folks can have their Social Security benefits held due to that mismatch as well. So that's a pretty significant issue related to, related to sort of specifically to transition that, for a person who has particularly bad luck or is particularly subject to police attention, we'll diplomatically call it, that it's much more likely that a trans person of color is going to get pulled over by the police, have that license revocation or suspension result in an arrest, and suddenly end up in the criminal system. And a lot of it is just, trying to do the right thing in terms of getting all of your documentation done, but missing the step that nobody tells you, right? It's not written in a rule anywhere. I mean, this is something that even as an attorney, I didn't know about until Al and other folks who are working in communities mentioned. So I just want to like really point that out, that when you're working with folks who have mismatched documentation, you're really going to want to be careful to make sure that, that you can help sort of close the bureaucratic loop as much as possible. And also just sort of, take an opportunity to double check some of these things, because there's a strong likelihood that the sort of bureaucratic machine has not caught up with this person, and that they may have some consequences coming. Kim, you asked for a PSA regarding debt adjusters, and then I also just want to lift up a comment in the chat that says that for Spokane area folks, the Way to Justice, which is an organization called the Way to Justice, has held State v. Blake record vacation clinics, and that they're hosting more of them. Their phone number is 509-822-7514. And another comment in the chat is noting that related to what I was saying a minute ago about SSA and Department of Licensing, that SSA requires some different documentation for gender transition than Department of Licensing does. And so it's not always possible that a person can even update both records. That may be changing under the Biden administration. The Department of State, for example, just lifted a lot of requirements for passport changes. And I have to imagine that the Social Security Administration will come along with that as well. So there is no medical letter requirement, for example, for federal documents now, which is great. But again, like I often think about like what the bureaucratic sort of burdens are that I carry in my life as a cisgender person, and how exhausting they feel. And then thinking about, what trans folks go through and how complicated that can be to kind of track down all of these different agencies and entities where you have your identity housed, let alone tracking down all of your creditors and all of these things, these other things. So this is it's a really real bureaucratic hurdle for folks that you can imagine when you're also dealing with discrimination and poverty, can be pretty onerous. So Kim, I'm going to let you do your PSA about debt adjusters, and give Jefferson a chance to close us out, and then we'll take another short break before we finish up with Janen's presentation.
Yeah, I just wanted to flag this issue of debt adjusters, debt consolidation. I was talking earlier in my presentation about kind of rescue scams. This is so common. These companies advertise and say, do you have a lot of debts? We'll negotiate with, the companies, and we'll adjust them. And all you have to do is pay this fee. Avoid, if a client says, hey, what do you think about this? Just stay away from it. And actually, in Washington, this is very, very highly regulated. There are options. There's consumer credit counseling, there's bankruptcy, there's some of the self-help materials that Jefferson talked about. But absolutely, if someone tells a client that for, $500, they can make $5,000 in debt go away, no, they can't. And then the other thing I would say is that this is also a space where payday lenders try to, rescue folks. A legal industry, highly regulated, but exceptionally predatory on our communities.
Thanks, Kim. Jefferson, any final thoughts before we head to break?
Just the payday lenders are another thing we ought to do something about, and they are particularly problematic for people without bank accounts. And other than that, everything's great.
Great. Thank you so much, Jefferson. We're going to take another 2 to 3 minute break. We'll be back here at 11:50 to start with Danon's presentation on bankruptcy. So hang tight, and we will be back here in just a couple of minutes. Thank you. Okay, we are going to go ahead and come back, assuming Danon is ready to go. Danon, you feeling good? All right.
Yep.
Great, thank you. Well, we are very happy to close our presentation today with an overview of bankruptcy basics for LGBTQ plus clients. You can imagine, as our conversation has progressed today, how we might culminate in this particular spot. And so we're really grateful to have Danon here with his many years of experience in this area. So take it away, Danon, thanks.
All right, thank you so much. Really happy to be here. I've been practicing bankruptcy and debtor creditor for more than 18 years, and this is a really different chapter and a really exciting one for me because I get to work with low-income clients. We have a statewide bankruptcy team at Northwest Justice Project, and I finally get to do bankruptcy without having to also, on top of things, deal with asking people for money. We get to use bankruptcy as a very strategic tool, so that's really exciting. When I started practicing, I'll just a couple of highlights of my career in bankruptcy and debtor creditor so far have been the Bankruptcy Reform Act in 2005. Many people know about it and that there were some reforms. The legislation was ironically named the Bankruptcy Abuse Prevention and Consumer Protection Act. I don't know that the act actually did much to curb the very minimal bankruptcy abuse that's out there, and it certainly didn't protect consumers. The word on the street about the Reform Act in 2005 was that it would that people wouldn't be able to file for bankruptcy anymore, and you couldn't discharge this debt and that debt. I would encapsulate the changes in the 2005 Act as really putting up a lot of barriers and creating a lot of busy work for debtors and their attorneys. I think it did discourage a lot of pro se filings. Before the Reform Act, I think that it was it maybe not easy, but it was a lot easier for pro se clients to file bankruptcy if you couldn't afford an attorney. Now, it's very difficult to recommend that people do file pro se. There are some tools out there, and we'll talk about some of them. Let me see if I can share this video. Okay. Hold on. I just included this for humor and as a demonstration of how bankruptcy does not work.
Hey, cuz. Heard you're having money problems.
No, you didn't.
Listen, I got the answer. You declare bankruptcy, all your problems go away. Creed Bratton has never declared bankruptcy. When Creed Bratton gets in trouble, he transfers his debt to William Charles Schneider.
How would that help, Creed? In Monopoly, you go bankrupt, you lose.
You don't go by Monopoly, man. That game is nuts. Nobody just picks up get-out-of-jail-free cards. Those things cost thousands.
That is a good point.
Bankruptcy, Michael, is nature's do-over. It's a fresh start. It's a clean slate.
Like the Witness Protection Program.
Exactly.
Not at all.
I've always wanted to be in the Witness Protection Program. Fresh start. No debts, no baggage. I've already got my name picked out. Lord Rupert Everton. I'm a shipping merchant who raises fancy dogs. That's the life. I declare bankruptcy!
Okay.
Thank you, Danon. That was my favorite moment of the day.
Excellent. All right. back to the slideshow. We've talked a lot about structural problems and barriers that our clients face, and one of the reasons I've really loved representing individuals and families over the years is that bankruptcy offers a lot of hope. It's an incredibly powerful tool, and when used carefully and strategically, it can change people's lives. Some of the things that I've done as a consumer attorney are helping people, not very often, but get rid of a second mortgage, save their house, stay in their house for longer, give them time to find new housing, and just a score of other things. I think it's, I just want to reference Kim's comments earlier about credit scoring, and there's a certain irony that that the credit scoring system, to eventually develop a good credit score, you have to obtain and use credit. But then on the other end of things, bankruptcy is there. I call it the big red button, and I am sort of the king of bad analogies, but I think that, again, as I mentioned, I think a lot of times people don't understand what it does or how it works. They don't know who gets to push the button, what happens on the other end. And clients can be harmed if you push it too soon or too late, with loss of property, other unintended consequences, debts following them out the other end of bankruptcy. This is a quote by Frank Borman, who's a former astronaut. He was the CEO and chair of Eastern Airlines and led that airline into bankruptcy. Capitalism without bankruptcy is like Christianity without hell. I did some digging and could not really find the context for his quote, but without consumer bankruptcy, individuals could be saddled with debt for life. They could be unable to acquire more credit. And I think we all want to participate in the economy. We all, in some sense, have to participate in the economy, and that participation would be limited. I was raised by two recovering Catholics from New Jersey, so I have all of the guilt and none of the pomp and circumstance. And there are a lot of, I think, there are a lot of similarities to the bankruptcy process, and the process of confession, going to a religious leader and asking for absolution. I thought about the Seattle 341 hearing room for meetings of creditors, and you go in and there's almost like this dais at the front of the room. There are these hardwood and pews, and there aren't any crosses anywhere, but the similarity to a religious experience is certainly there. There are a multitude of reasons that people file for bankruptcy, and I think we're all familiar with some of them in our practices. The top three I put at the top of this slide here: divorce, medical bills, and unemployment or job loss. Particularly now, with people having lost income because of COVID. They've been unable to maintain to keep paying their rent, to keep paying their mortgage payments. I think bankruptcy is very cyclical based on what's going on with the economy, and I think we're about to see an uptick. Other reasons are disasters, a business failure, lots of credit card debt, and credit card debt, I think, has behind it not just irresponsible use, which I frankly have rarely seen. A lot of times people are paying for life's necessities on their credit cards. I kind of stole this slide from another website, but lack of financial planning, it's definitely a component, but the reasons that people do file for bankruptcy are complex and varied. I read once a statistic that more people file for bankruptcy than divorce every year. So that's just something to keep in mind when you're advising clients who may feel there are a lot of feelings and emotions around bankruptcy. I think by the time people come to my office, they've had some type of financial trauma. They've had creditors breathing down their backs. Their unfamiliarity with the legal system can cause trauma too, because they just don't know what to expect, and they may be hearing all sorts of things and threats, and and unsubstantiated, we're going to throw you in jail and things like that from collection agencies in particular. So all that is just to say that we as attorneys and counselors can, I think, in advising clients about whether or not to file bankruptcy, just bring them a lot of relief and help them sometimes process the financial trauma that they've been through. Bankruptcy is a balancing act. It's provided for in the Constitution that basically just says Congress shall provide for a uniform system of bankruptcy laws. And this is, arguable for those of us who are familiar with the nitty-gritty details of the code, but it balances with a fresh start for the debtor and fair treatment for creditors. Because of how the legislative process works, some creditors are treated more fairly than others, but we probably don't have time to get into that today. Some common myths about bankruptcy that we might be aware of. Number one, bankruptcy ruins your credit. Excuse me. In my experience, I spent sort of the first half of my career before going into nonprofit and legal aid, representing bankruptcy debtors, and then the second half doing collections and foreclosure work for HOAs and condo associations. So I've seen this from both ends. There is, from my experience, bankruptcy, the impact of bankruptcy on a credit score is that there is a temporary dip. However, people are typically, if they otherwise qualify, are able to qualify for a home loan as soon as anywhere from 2 to 4 years after a Chapter 7 bankruptcy is discharged. There's with in most bankruptcies, there are a lot of debt is wiped out, and it's just people are a much better credit risk as far as mortgage lenders are concerned after discharging a lot of consumer debt. Another myth is that people can file for bankruptcy as often as they want, and I'll show a slide in a minute on that. The third myth is that you lose all your stuff. When I first started practicing, I didn't know anything about the process. I had some idea that the bankruptcy trustee was going to go into people's houses, and I think clients have this idea too. Most of the work that's done by the bankruptcy trustee or by the court is done on paper by examining documents. I have occasionally represented debtors who get called in for a Rule 2004 exam, which is like a debtor's exam, an extended deposition about assets and debts, income and expenses. But people losing their stuff is a myth. Personal belongings, household goods, things like that are usually exempt. Homes and cars are a little bit more complicated. Myth number 4 here, that you get a free house or free car. I have heard that from time to time. This is not true. There is, like I mentioned, bankruptcy can be a powerful tool, and it can sometimes adjust secured debts or split secured claims into a secured and unsecured portion, and help people in really powerful ways in that regard. Number 5, you get to choose what debts to include. I've told clients that that what you file for bankruptcy, and the mere act of filing your bankruptcy paperwork drags you kind of, in a sense, get dragged into the process. All of your assets, all of your property, all of your debts get dragged in, and the goal in obtaining a discharge is really to provide. It's like that analogy about what to tell people on the first date. You don't want to overshare, but you also want to disclose just the right amount of information. And I think that's one of the things in bankruptcy practice that is an interesting art. Collecting information. A practice tip is that I tell clients that that I want the process to actually, with my office, to be as efficient and simple as possible, but also I want to have made the process of preparing their bankruptcy petition and providing information to me. I'd rather ask you a lot of questions about your financial situation so that by the time that we go to your hearing, you'll be prepared for anything that the bankruptcy court, that the bankruptcy trustee throws at you. Number 6 myth is that bankruptcy fixes your debt problems. There are a lot of debts that are not discharged in bankruptcy, and we'll touch on that a little bit later. One very common myth is that debtors are deadbeats, and I just chose this picture of Elizabeth Warren. I think it's of her at University of Pennsylvania in the 1990s. She was the author of my bankruptcy textbook in law school, and a lot of her early research, she started doing that research and wanted to. She went into her scholarship believing that she was going to essentially document the widespread abuse, the widespread misuse of the bankruptcy system, and believing that people were either working the system or that they were irresponsible in incurring their debts. She actually concluded that abuse was rare and that the legal framework for bankruptcy was poorly designed. And another big piece of her research, and that she's written many books and scholarly articles and shorter articles about, is that because so much of our country, the schools that your children go to are based on where you live, and the funding that your children's schools receive are based on where you live, that there are a lot of two-income families that have to go broke because when two parents are working. And she actually talks about the elements of sexism and misogyny, and talks about that. She comes at things from a that typically it is in an opposite sex marriage, it is typically the husband who is working, but it isn't always. And essentially that when one parent loses their job or has a reduction of hours at work, that then the family is then not able to weather the storm, and that's a major cause for people filing for bankruptcy. She just talks about the zero-sum competition for the educational opportunities, and that it's been expressed as either skyrocketing prices for houses in good school districts or escalating tuition at public universities. Anyway, enough about Elizabeth Warren. Just a couple of examples of people who I've represented or colleagues have represented that have had to file for bankruptcy. A single mother who was diagnosed with cancer and had no health insurance. I went to the 341 hearing with this client, and the trustee somewhat sarcastically asked, "Well, I see that you have a lot of medical bills here on your petition. Did you get in a car accident or something?" And she just looked at him totally deadpan and said, "I had cancer and I had no health insurance." And he definitely ate crow after she said that. Represented a woman who had to quit her job to take care of her mother with Alzheimer's. Our capitalist economy just doesn't, oftentimes doesn't provide leave benefits or account for someone who's the primary caretaker for an aging parent or for their children, and can sometimes result in bankruptcy. Small businesses that fails, debtors have often personally guaranteed loans, oftentimes without even knowing it because of boilerplate in business credit card agreements or loan agreements. I know of a couple who owned a car dealership whose son was badly burned in a house fire, and needless to say, that led to major financial problems for them and their business. I just want to give a quick,
Hey,
yes.
Danny, can I interrupt for just 1 minute about
Please do.
articles? One thing that really stands out about those that sort of links sort of as a through line back to even where we started in the presentation today is how with LGBTQ folks, where we have such non-traditional family arrangements and things like that, like we are very often going to be in the same situation as the folks that you're talking about, you know, the folks that you've represented in your history, right? Like that the experience of having to choose between, can I stay employed and not, you know, have to file for bankruptcy versus, do I leave my loved one who I maybe doesn't count as a family member under our Paid Leave Act or other kinds of protections that are built around the nuclear family, right? Like those are impossible questions that our communities are very often in the position of having to answer. And so these are areas that sort of is, you know, when I started us and said this is sort of a culmination of everything we've been talking about, that's a really great example. So I just really wanted to lift up that experience. So thank you for giving me some grace in to grab a couple minutes from your presentation.
Absolutely. Thanks, Denise. You know, I think it was sort of, I mean, the example of just how varied and diverse LGBTQ families are, the bankruptcy system, and you know, who's a dependent. It's a little bit like who's a dependent for tax purposes, and I've had to advise clients many times, you know, I understand that your elderly parent has all these needs, and you know, oftentimes medical needs, you know, that you're housing them, but you know, this expense that you're incurring every month is not something that we can include for this purpose or that purpose, or that the court is going to look at for in determining your ability or not to repay your debts. So thank you, Denise.
Yeah, thanks.
All right, I've focused on just giving a really broad brushstrokes overview of the different chapters of bankruptcy, and we'll talk briefly about the process, because I did debtors work and then creditors work, and then went into nonprofit and legal aid. I'm just getting back into representing consumer debtors and families and individuals, so I have shied away from updates on case law or anything like that, but if anyone has a question, I am more than happy to try and answer it. So the most common types of bankruptcy are Chapter 7, which is the most common type. It's also known as a liquidation or a straight bankruptcy. I would have to look back and at my bankruptcy reference materials to figure out where that term came from. Like, I'm not gonna be filing a straight bankruptcy. Anyway, so there's no repayment plan in a Chapter 7. Individuals and businesses can file for Chapter 7. The essence of what happens in a Chapter 7 is a private individual, a private official called the Chapter 7 trustee is appointed to essentially oversee and administer the case. Most of the panel Chapter 7 trustees, they're appointed by the US DOJ's United States Trustee Program. Most of the Chapter 7 trustees are attorneys. There's some accountants and other business people. They take a look at the bankruptcy schedules that are filed with the court. They ask for documentation of income, expenses, assets. They're going to want to look at tax returns. There is one hearing that's held typically called the 341 hearing, or the 341 meeting of creditors. And it's the 341 because that's the section of the code that mandates it. Clients are very concerned about this. They're concerned that oftentimes that they're going to be on the hot seat for an hour. And I just went to a 341 on Tuesday, I guess that was yesterday. And the trustee had probably 2 minutes of questions for my client, and that was it. And if you're prepping your client in advance of the 341, there shouldn't be really any surprises. And then after the hearing is over, you're looking at typically about 60 days until the court enters a discharge and the case is closed. The exception to the short time frame on a Chapter 7 no asset case is going to be when the Chapter 7 trustee finds assets in a case. That could be money or property that can't be covered or protected with available exemptions. In Washington state, consumer debtors can elect either the state exemptions or the federal exemptions. There was a recent change to the homestead laws. Now, when I started practicing, the homestead exemption was $40,000. Then it went up to $125,000, which shocked a lot of people. The Chapter 7 trustees lobbied against it in the legislature. They knew that they would be selling fewer people's homes. And now the exemption is the greater of 125,000 or the median home price in your county based on the previous calendar year. And basically it's referencing information that's collected and maintained by the UW Center on Real Estate Research. So this is a huge boon for people who, particularly like seniors who are on a fixed income or who just have a lot of equity in their home. You know, in an area like Seattle, and for many debtors who are homeowners, the equity in their home has skyrocketed in the last few years by, you know, just by market forces. So I was talking to a client the other day who's in Pierce County, and her homestead exemption is now, I think, upwards of $300,000, and even with that, she still has some unprotected equity. And so we're talking about what might happen in her Chapter 7 with the trustee looking at selling her home. So I digress. Chapter 7, most Chapter 7s are over in about 90 days. Most are over in about 90 days. If the trustee finds assets there, the time frame is pretty unpredictable. Let's see. Okay, so the second most common type of chapter of bankruptcy is a Chapter 13. These are most commonly known as a wage earner plan. Consumers can reorganize their debt. They make payments to a Chapter 13 standing trustee who collects payments from debtors and then in turn makes payments out to creditors. This is actually nice on the back end in dealing with mortgage or vehicle creditors or any debt that can't be discharged, and a client is making payments through the plan because you have a record of those payments during the plan. The goal is on the other end, in like a save the house or save the car Chapter 13 case, is to come out on the other end with the arrears caught up and with the ongoing payments current. And a huge benefit of the Chapter 13, besides stopping foreclosure or preventing repossession of a car, is to come out on the other end with payments caught up and with that record of payments that have been made for 3 to 5 years is the payment plan length, depending on a number of factors. Another type of bankruptcy is a Chapter 11. This is a reorganization that's mostly used by businesses. Think about United Airlines. A consumer may elect for Chapter 11s. For individuals, you usually see Chapter 11 used where there's high income, high debt. We're not talking your usual consumer. We're talking somebody that you know, maybe owns a business and their business is in financial difficulty and they're having trouble making their Bentley payments or something like that. Okay, some other types that I'll just skim over really quickly are a Chapter 12 for family farmers and fishermen. This is actually more common than you would think in Eastern Washington for farm businesses. Chapter 9 is for municipalities. I believe municipalities and governments. I want to say Orange County filed a municipal bankruptcy several years ago. And then Chapter 15 provides for cross-border insolvency cases and proceedings, debtors, and where a bankruptcy debtor may have assets in more than one country. So you're typically not going to be dealing with these in your average consumer case. I also meant to say that I'm not sure who's keeping statistics. It may be the U.S. trustee, but probably 80 to 90%, oftentimes more, of all Chapter 7 cases are no asset cases, meaning that the trustee doesn't find any property or money or claims that could be liquidated and used to pay creditors. How often can you file for bankruptcy? A Chapter 7, generally you can file every 8 years, and that's from petition date to petition date. For repeat filings, I have a chart that I'll show, and you can take a look at that when the slides come out. I just put it in as a, be sure to check the code, talk to your bankruptcy practitioner colleagues. The bigger concern that I think a lot of people are unfamiliar with, and that came about as a result of the 2005 reforms, are restrictions on the automatic stay for repeat filers. On the creditor side, I was representing an HOA, and we had a we had a debtor homeowner who had filed a Chapter 7 in the past. Okay. Then they filed two Chapter 13s within a year of one another. And one of the things that we were able to successfully get from the bankruptcy court was an order declaring that the automatic stay was not in effect at all in the third bankruptcy. And so we were able to proceed with a sheriff sale. So that's one of the ways that I think it's very important for attorneys who are filing bankruptcies on behalf of clients. There are just a lot of things to check into. Look at the code, look at the National Consumer Law Center that Jefferson mentioned earlier has a really great treatise on bankruptcy. And just be very careful. If you file and there's no benefit of the stay, then your client has that debtor had a third bankruptcy on their record, and they didn't have the benefit of the automatic stay to stop the foreclosure. This is a chart of the discharge limitations. There's also something that is not in the code, but it's informally known as a Chapter 20, where clients file a Chapter 13 to save the house, save the car, deal with debt that can't be discharged in a Chapter 7, and then file a Chapter 7 to essentially eliminate any other debt, or they do it the other way around. All right, just a basic overview of the Chapter 7 process. I've sort of hinted at that there's a pretty lengthy process of collecting information from your clients. For our clients at Northwest Justice Project, this process is pretty streamlined. I talk to clients and say that it's kind of similar to applying for a mortgage loan. Bring me your last 2 to 3 years of tax returns, pay stubs going back 6 months. One of the things that the 2005 reform put into effect was a 6-month look back at a debtor's income, and if over the last 6 months, the 6 months before the debtor filed for bankruptcy, if this means test form shows that the debtors have the means to repay their debts in a Chapter 13, then there's a presumption that the Chapter 7 filing is an abuse. That abuse can usually be easily overcome, particularly in situations where clients have lost a job, lost income, where the circumstances that led to that presumed abuse are no longer there. One thing to keep in mind about the means test is that it uses not the actual expenses of the debtor, but the IRS collection financial standards that the IRS uses in determining what people can pay who are facing tax debt.
Hey, Dayton, I'm going to give you a 5-minute warning, please.
Okay. All right. The automatic stay goes into effect when the petition is filed. I kind of already referenced the exceptions for repeat filers, and then the debtor is required on the schedules to disclose all of their assets, their debts, income and expenses on prescribed forms that get filed with the court. The forms, most bankruptcy attorneys use software to complete these forms. I think that even though when you talk to some trustees and bankruptcy judges, some of them really believe that they're individuals that can complete them, that they're easy. I think that when you look at the combination of just being overwhelmed with the legal system, potentially having been done harm by, other parts of our legal system, and any financial trauma or other trauma that at least our clients are dealing with. I think it's oftentimes having an attorney that can quickly and efficiently fill out those forms. That's a major benefit to clients. Like I mentioned, the Chapter 7 trustee looks over the paperwork, and if there are any assets, if there are any non-exempt or non-protected assets, then creditors, those assets are liquidated and used to pay creditors. Even in an asset case, a debtor will still get an order of discharge. There are a number of non-dischargeable debts that are not discharged in bankruptcy. One of them, of course, is student loans. What the bankruptcy code and case law says is that you have to show that it's an undue hardship to repay those student loans. What I tell clients, unfortunately, is that you would have to show that you can't work any job or earn any income for the rest of your life. And I tell them that it's tongue in cheek, but it's a very, very high standard. There's some talk about lobbying for a legislative fix for that, and the consumer bar has been looking at different ways to work on that for a long time. A Chapter 13 is very similar. Like I mentioned, there is a 3 to 5 year repayment plan in a Chapter 13. One very powerful thing in a Chapter 13 is that there's a super discharge. You can discharge things in a Chapter 13 you can't in a Chapter 7, including domestic support obligations. We don't have time to get into that today, unfortunately, but generally speaking, debts arising out of a divorce, willful or malicious injury, so tort claims, certain court fines and penalties. So sometimes people will use a Chapter 13 to deal with court debt. Debts that were previously denied discharge, and here's a biggie, post-petition HOA or condo assessments. So student loans are still non-dischargeable. Debts related to fraud, debts that weren't disclosed on the petition, and debts related to drunk driving causing injury or death are not dischargeable. I'll just touch really quickly on some of the, I've referenced some of the LGBTQ bankruptcy issues. Say the biggest one since Obergefell is marriage. If you are married, you can file a joint petition because there's nothing more romantic than going broke together. But this does save a lot of money for clients who hire a private attorney. You do have to disclose, unfortunately, any AKAs or FKAs, including dead names, previous married names, etc. This is just something that has to be done, and it can be very painful for many queer clients, trans clients, but you just got to do it. LGBTQ households, the entire household income has to be disclosed on the schedules, and this is a little bit more of an art. If an LGBTQ couple is not married and keeps their finances pretty separate, there have been cases where I've been able to file, and we just list the filing debtors, income and expenses. I did also want to just mention that there's a fee waiver available for Chapter 7 cases. You essentially have to earn 150% or less of the federal poverty level. For the most part, I would say that the actors in the system, the trustee, creditors, and their attorneys, not uniformly. In the Seattle area, they really just want to do their jobs efficiently. And I have had more, I think, harassment by trustees who, with clients who have received a fee waiver. They've harassed clients about if they have a spouse or partner that has money to pay the filing fee. Part of that's because Chapter 7 trustees receive, I believe the compensation is still $60 for every no asset case. So they're a little torqued that they're not receiving their compensation. Kim referenced some alternatives to bankruptcy. There are several, including credit counseling services. There is pro bono help available through volunteer attorney programs. NJP is a good resource. Our statewide bankruptcy team is probably about a year old. And there's some online tools that are coming available for people that we don't have time to get into today. Upsolve is one of them. Those are something that I believe that that folks should talk about with their attorney to figure out if it's something that's right for them. I just threw in this Oregon Trail graphic because I do believe that that clients are best served having an attorney to guide them through the process and to make the process less stressful for them. We've all been down that Oregon Trail fording the river thing where the wagon goes under or the wagon tips over, and we don't want that to happen to our clients. And finally, a fresh start isn't a new place, it's a new mindset. Bankruptcy's a really powerful tool. It gives a lot of hope to our clients. And I just think it's a great thing to keep in mind when your clients come in and that they have debt problems that there doesn't seem to be an easy solution for. And I think that's the end of my slides.
Great, thank you so much, Danon. That is the close of our presentation today. We are a little bit over time, so we will go ahead and feel free to email us if you have any follow-up questions, anything that you want to make sure that we cover in another presentation. For any logistics, some sort of closing out logistics for us, we will provide a link to a course evaluation and as well as a PDF of the materials and a link to this recording in our in a follow-up email to everyone who registered. So if you were only able to attend part of the presentation today, not to worry, you will get the rest by recording. We also will handle submitting CLE credit to the bar for anyone who registered and attended and gave us a bar number. If you did not give us a bar number or you registered but did not attend and are watching this later, you're going to have to take care of your CLE credits yourself. We can help with that, but can't do it for you. For everybody that did attend today and give us a bar number, we'll go ahead and submit your credits for you. So keep an eye out for the eval link. We do really value evaluations. We read them all, and we use them not only to give feedback to speakers, including our Q Law Foundation staff as speakers, but we also use them to develop areas where folks feel like there might be some more training opportunities needed. So with that, I will say thank you everyone for attending today. Have a wonderful rest of your day. Thank you for caring for LGBTQ+ communities so deeply. And thank you most of all to our speakers, Jefferson, Danon, Al, and Kim, for your deep expertise and your kindness and generosity today. Thank you so much, everybody. And we will see you all again soon.